Lordship, I'd like to mention item number 10, 11, and 12. Lordship, this item number 10, 11, and 12 may be fixed after 3 weeks.
What is the matter about?
Lordship, as for 10 and 11, the leading counsel is Mr. M. Kato. So he is having some difficulties.
Now it's in item number 10, Lordship. Amount has been already released in terms of the judgment. Lordship.
Let the matter be called up.
In
You
regard,
wait for some time.
Lordship, 11 and 12.
You wait for some time.
Always.
May it please your lordship. Lordship, I would like to mention item number 3. This is regarding a service matter. Here, your lordship, petitioner is yet to file affidavit in reply. So I need your lordship time.
You wait for some time. May I please, madam? Madam, I beg to mention item number 15, madam. Yes. In here, madam, the respondent had supposed to file affidavit in opposition. You wait for some time. All right.
My lordship. Lordship, I beg to mention item number 6, 7, 8, lordship.
Yes.
Leading counsel is out of station, lordship. Matter may be released after 1 week.
What is the matter about?
Lordship, it's petitioner is appointed as SSA in a teacher in SSA, lordship. And after in 2010 he is regularized and regularized as then promoted to TGT teacher, lordship. And after notification is issued that he has returned back as demoted as a
You wait for some time.
Yes.
Yeah, please, Lordship. Lordship, I also would like to beg to mention item number 21 to 23, Lordship. Lordship, in this matter, Lordship, earlier it was being represented by the IHOT, Lordship. Now, after the senior counsel has been being appointed as the AG, Lordship, the client has to take the give to the briefing to some other senior, Lordship. So therefore, Lordship, since the condition has been obtained from the other party also, Lordship, this matter may be taken up after 4 weeks, Lordship.
What is the matter about?
Lordship, there in this matter, Lordship, basically the private respondent and the petitioner, Lordship, they are challenging for the post of superintendent of engineer, Lordship.
Matter survives.
Lordship.
Because challenging the appointment of superintendent engineer.
Lordship, promotion, Lordship. Matter relates to promotion, Lordship. Since there was a 2 notification, Lordship, in 2014, Lordship, there was a 1 notification, recruitment rule, Lordship, and the OM dated 2002, Lordship.
All right, all right. On the prayer of Mr. P. Garam, counsel for the petitioner in
Item
both
number,
the case, I think.
no, Lordship, in the
In-
item number
in-
21, I am the respondent, Lordship, private respondent.
In WPC 3 of 2022, listed after 2 weeks to enable the petitioner to engage another counsel in place of I. Chaudhary, the London senior counsel.
Lordship, maybe after 4 weeks, Lordship.
4 weeks.
Lordship.
Okay, 4 weeks.
Lordship, in the item number, Lordship, 22, Lordship, there is an interim order, Lordship. That may be continued till the next attendance date, Lordship.
Yes. Any objection with the continuation of the interim order? Who is for the other side?
No objection, my lord.
No objection.
No.
Okay. Interim order passed earlier. Shall continue till the next date of listing as Mr.
Eddie Pine, sir.
N.E. Pine,
Eddie, E-double-D-I-E, Eddie.
Learned counsel for the respondent number So and so for continuation of the interim order passed earlier till the next date of list. This is a consented, no? Okay.
Deeply obliged.
Which respondent number? Okay, you find out the private respondent. All right, lots. All right, but you are without a gown.
My apologies for that, sir.
Lordship, in item number 21, Lordship. The direction may be given to the government also, Lordship. They have to file the affidavit also, Lordship.
Then you will have to wait. We'll have to look at the records. See, what you will do, even if the state government has files affidavit, first you settle your senior counsel in place of Mr. Chaudhary.
Lordship.
Huh? You are unarmed now. You deploy a soldier. Thereafter we'll take up.
Lordship. After 4 weeks, Lordship.
After 4 weeks.
Deeply obliged.
Mayor, my lordship, I beg to mention item number 17, my lordship.
Yes.
This matter may be listed after a week, my lordship.
Why? You wait, this is 2017, so 16 matter. What is the matter about?
They are challenging the decision passed by the executive magistrate Longding regarding the paternity of a child. Maintenance,
What is Tapak?
he is not present today. I have taken,
You wait, we'll pass on.
and one more, my lordship, item number 31. This matter may be listed tomorrow, my lordship.
Huh?
Tomorrow,
Tomorrow, not possible. What is the matter about?
suspension,
Ah,
departmental proceeding. my lord.
who is for the petitioner?
We have taken consent from the petitioner, my lord. T.
Huh?
Tamil.
Not tomorrow,
Day after tomorrow, my lord.
after 3 weeks. We can't allow the listing of a case in such a short interval. We have to give place to the other case. On the prayer of Ms. K. Wangmu, Learned Counsel for the Learned Government Advocate with the consent of Mr. L. Parme, Learned Counsel for the petition listed after 3 weeks. Yes,
My lord. My lord, I beg to mention item number 20, my lord, on behalf of A. Saring.
Item number 20.
Yes, my lord.
Yes.
Due to his daughter have health problem, my lord, he is unable to come today.
He has a health problem.
Her daughter's, my lord.
Item number 20.
Yes, my lord.
Yes, Mr. Son, we'll assume this case. Mr. Saring appears to be a
My lord,
health problem.
uh,
Oh, all right. This, an adjournment is sought on behalf of Mr. Saring. On the ground that Mr. Saring is in his post. So this matter will be listed after
my lord, 3 weeks, my lord, the pleading are all
3
over, my
weeks.
lord.
Okay. You, huh? 2 weeks, okay, 2 weeks.
My lord, list this matter for admission, my lord. Pleading are already over, my lord.
Okay. For admission. All right. Okay.
Yes, my lord.
Lordship, I beg to mention item number 1 on behalf of K. Law.
Item number 1.
Yes, Lordship.
1 will be just called now. You wait. Huh? Yes.
May I please, my lord? I beg to mention item number 30 on behalf of all father. Matter may be listed after
30.
3 weeks.
Okay. After
3 weeks.
3 weeks. Okay. On the prayer made on the prayer made on behalf of Mr. O. Father. The counsel for the petitioner, please pick after 3 weeks.
Obliged.
Lordship, I beg to mention item number 28 and 29.
Yes.
We have to file affidavit in reply, so 3 weeks time may be given.
Oh, you wait. Let the matter be called.
May it please the lordship.
Yes.
Lordship, this particular petition is for appointment of arbitrator. The said contract agreement CE/ANK/20/2016 and 17 was awarded to the respondent firm on the 22nd of November 2016 for an amount of rupees 58 lakhs 24,670 rupees. According to the work order, which is Annexure 2, the phase 1 of the said work was supposed to be completed by 17th Feb 2017, and subsequently 50% to be completed on 18th April, 75% to be completed on 17th June, and 100% work to be completed by 16th August of 2017. But the respondent firm had not even commenced the work we have sent several notices to the respondent firm regarding the same to commence and complete the work in the contract agreement. The contract agreement was for supply and stacking of stone boulder quarried stone of size 15 centimeter to 25 centimeter at kilometer 13.00 on Daporijo Taliha Road stone crushing operation for 2.00 kilometer linear servicing works between kilometer 11.00 to kilometer 12.00 and kilometer 14.20 to kilometer 15.20.
Where is the contract agreement?
Lordship, the contract agreement is on Annexure 1 at page number 12.
This is not a contract agreement. This is not a contract.
Lordship, in page number 12,
Yes,
para number 3, it is mentioned here that this contract is allotted, which will so and so, which
Okay.
will be.
where is the agreement between the parties?
Lordship, the contract agreement has not been annexed here. This is the,
On what basis you are seeking appointment of an arbitrator?
Lordship, if your Lordship may peruse page number page number 34, Annexure 9. It is a letter from the respondent firm to the Chief Engineer Project Arunang. They have sent us a letter saying that they will be paying the risk and cost amount in installment basis with annexing the DD for 1 lakh rupees as well.
Is there an agreement between the parties or not for this work?
Yes,
Where
Lordship.
is that? At home?
Sorry, Lordship.
What is the agreement? Is it with you?
No, Lordship, it is not with me at this
You tell
moment.
this court, what is the basis for appointment of an arbitrator under section 11 of the Arbitration Act 1996? But I suppose this is an application under section 11.
Yes.
What is the basis for appointment of an arbitrator under section 11? So you go through it and come back. When?
Lordship, the notice may be issued and I will file an additional affidavit with the agreement.
All right. Then what happens? Today notice on this arbitration petition will go to the respondent. Then when you file that additional affidavit, we'll again have to issue notice to the additional affidavit. Then you may have left out another material facts. You will again file another additional affidavit. Then again, there will be 3 notice. So we will list it next week. You
Lordship,
examine the case and come back.
next week. Lordship, I have come from Guwahati actually. So,
Tomorrow also we can list it. We have
tomorrow,
no issue. We'll list it as per your convenience.
okay. Tomorrow I will have to talk with my senior, Mr. CGC, Mr. SK Medhi.
You have to tell us, you have to tell the court what to do. Today, in the form and content of this arbitration petition, no notice can be issued by the court. Either we dismiss and dispose of. That is one option. And another is to give you, you have to tell us what is to be done. Otherwise, we'll pass order.
Lordship, if I may be allowed, can I inform after some time?
Okay. All right.
Please, madam.
Ah.
My lord, by this writ petition, my lord, I'm seeking direction to the responding authority, my lord, to initiate the, my lord, land acquisition process in respect of my private land, my lord. Now, the deputy commissioner, my lord, considering my representation, my lord, has rejected my prayer, saying that since 1952, this Assam rifle has been in occupation of the land. Now, admitted position is that, my lord, so far government land is concerned, my lord, it has to be either acquired by invoking the law of acquisition. Second, my lord, the land has to be donated by the public, my lord. The admitted position on the face of record is, my lord, this has not been acquired or donated in the manner known to law, my lord. This is the admitted position. Now, so far, my lord, then this is not the government land, my lord.
You tell one instance in the state of Arunachal Pradesh,
My lord.
where the land was not parted with by the parties
My lord.
in the same manner as we have parted with.
My lord.
Your land is under occupation of Assam Rifle.
So it is under the occupation of Assam rifle.
Since when?
1952, my lord.
1952.
My lord.
We will not intervene here.
My lord.
We will not intervene here. See, you don't have a right to be acquired.
My lord.
If you want to get back your land, you seek remedy, you get back your land in accordance with law.
No,
know,
now the issue is, my lord.
How it is your land, first of all. Now you tell this court.
My lord, this is my land, my lord, since my great-grandfather, my lord, they were in occupation of the land. Since, my lord, since I am the, my lord, successor interest of the...
In 1952, your grandfather parted with your land.
Temporarily, my lord.
Temporarily.
My lord.
Now suit for the period of limitation for filing of the recovery of
So far
possession.
law is concerned, my lord, this is the saying, my lord, so far because government cannot take the plea by way of adverse possession because the state being a welfare state, my lord. They cannot expropriate the land of the private people, my lord, without following the due process of law. My case is simple that, my lord. My lord, this is for if it is for the public purpose, my lord. I don't have a fundamental right, my lord. But so far I have a constitutional right, my lord, and it is considered as a human right also, my lord. Now my limited prayer is, my lord, of course, I'm saying, government is saying, my lord, that the deputy commissioner is saying.
Any other issue you have raised apart from that?
My lord, yes, I have raised, my lord, so far, my lord, government.
Otherwise we will dismiss it. Yes.
My lord, so far, my lord, this adverse plea, the deputy commissioner is saying, my lord, that cannot be taken so far, state being the welfare state, my lord. Now, my lord, law is said that the law is very, it is tried law, my lord, that any land, my lord, if because my lord will see that the ADC.
See, if we allow your petition,
My lord.
we will have to allow all the petitions filed by anybody for the advanced landing grounds you have constructed. Capital complex you have established, district headquarters you have established, schools you have established.
My lord. Those were the instances donated, my lord. Donated by the public one. Here, my lord, here, my lord, the state government, my lord, admitted, my lord, there is nothing on the record to show that this land was either donated or acquired under the procedure known in law, my lord. Now, my lord, the law is very clear, my lord. The government, if wants to acquire the land, there is no bar, my lord. Government can do it, my lord. But the thing is that, my lord, they cannot just, my lord, say, my lord, because of the adverse position, now this land has become the government land. It is not, my lord, permissible under the law, my lord, so far, my lord. Now, what we are saying, my lord, that now very interesting, my lord. Now the authority, my lord, if they want to proceed with the land, my lord, they have to follow the, my lord, land acquisition process, my lord. And at that point of time, my lord, the claim and objection has to be heard from the people, my lord, public, my lord. Thereafter, they can proceed ahead, my lord. Similar nature of case, my lord, disposed by this honorable in the year 2005 in respect of the, my lord, ALO, my lord. There also, my lord, the same observation has been made by this honorable court, my lord, saying, my lord, that in that case also the land was given to the Assam Rifle, was in occupation. Then said, my lord, that it was not donated, my lord. Thereafter, my lord, direction given, my lord, that it has to be acquired in the process known to law, my lord. Only because, my lord, apprehension, because some people will claim, because my right cannot be, my lord, curtailed also, my lord. Because this is my constitutional right and this is more a human right, my lord. And my lord knows, my lord, so far, state of Arunachal is concerned, my lord, the land law is very clear, my lord. So far, the areas land, my lord, which are not acquired by the government, it belongs to the people, my lord. Or tomorrow, otherwise, what will happen? Government will go and take any land, and so many people are there. They are rustic villagers, my lord. If they have not made any claim, so government cannot come with the plea that this is our ancestral land, my lord. My lord will find the deputy commissioner, my lord. May I take to my page number 63, admitted position, my lord, that nothing is there on the record to show that government has ever acquired, or there's nothing on the record to say that it was ever gifted by the public, my lord, to the government, my lord. Now, in that situation, my lord, the land becomes, it's a private land, my lord.
You are challenging some land allotment also?
Land allotment, because, my lord, ground is that since this is not the government land, government cannot allot land to the Assam Rifle, my lord. How the government can allot the land to the Assam Rifle when the land doesn't belong to the government, my lord? And, my lord, that adverse plea cannot be taken. Law is very subtle position, my lord. So far, this right to property is concerned, my lord.
No, we are not, see, adverse possession is so far as the title is concerned.
My lord.
Huh? We are not on the title.
Yeah.
We are not on the title.
Now, my lord, the law is very clear, my lord. Government has to follow the law to say that this is my government land.
Where have you described your relationship with the land?
My lord, sure. My lord, paragraph 5, my lord. Writ petitioner are the rustic relative farmer who are only countries. So the writ petitioner is presently serving government. They are the great grandchildren of late Taibung Yongkuk, as their deceased father so and so was the son of so and so. The above named grandfather, this was the Taibung Yongkuk, my lord, who my lord allowed the Assam Rifle, my lord, temporarily to settle in that place, my lord. Para 5 and 6, my lord.
Yes, Mr. Counsel, what do you say?
My lord, if these sort of claims are to be entertained, my lord, there will be several litigations, my lord. My lord, I will just take your lordship to page 116. This is type copy of Annexure 15, my lord. It is their own petitioner's document.
116.
Yes, my lord. This is a translated copy of an SMS version, my lord, starting at 114. The all order, my lord. May I read, my lord?
Yes.
To Sri Taibam Yungkok GB Khatyang Yung village. This is to inform you and your villagers that the existing Tirap assistant political officer has been proposed as a revenue circle. If this proposal is approved, then your village will be included under the Tirap revenue circle. In case you have objection on the proposal, you may inform this office.
Yes.
My lord, in case you have objection on the proposal, you may inform this office. My lord, from this, what I can gather is that it was taken by as a revenue circle, my lord, by the government. And whether they objected to it or not, whether they voluntarily gave it in donation, agreed to the proposal that it will be taken as a revenue circle. After that, since there has been there is no pleadings to this effect, whether there was any objection or not. Whether they claim any compensation at that point of
allotment is to the same land.
Same land, my lord.
There are two allotments.
Two allotment, my lord, it covers this entire land, my lord.
Huh?
This entire land which I am claiming, my lord, this covers these two land allotment. Under these two land allotment.
This land allotment.
Land allotment. Now, my lord, what happens in such case?
So their occupation has now been regularized by the government.
Yes. Now government is saying that now, despite admitting
where is that this 450 acres of land which was temporarily allowed to be occupied by the Assam Rifle in 1952,
my lord,
have now been allotted by the government by these two allotment orders.
My lord,
This is 342
plus my lord 72
acres.
My lord, acres.
342 plus 77 makes it to 450.
72, 342 plus it will be 77. Then it will come 9, 4, 11. More than 400 acres. It's coming around, man.
Now, where is that statement of yours that the same land has been allotted?
My lord.
439. It comes to about 439 acres.
My lord will find paragraph 12, my lord.
12.
My lord. That the writ petitioner to dear utter they belatedly came to know the state government is claiming the land in question as the government land has allotted the land measuring so and so, bearing so and so, and another land measuring so and so to the Assam Rifle. The land in question has been allotted on lease basis and the state has been receiving the huge so and so, my lord. Therefore, my lord, feeling aggrieved, representation was filed, my lord, to the additional deputy. Thereafter, my lord, this honorable, when representation was not considered, this honorable court directed ADC to consider the representation. Then ADC submitted the report saying, my lord, that there is nothing on the record to show that this land was ever acquired or donated. And he said that my lord, he doesn't have any authority under the Land Acquisition Act 2013 Therefore, the matter referred to the deputy commissioner. Thereafter, deputy commissioner wrote back to the director of the land, my lord. Now, here the problem is started, my lord. The director of land, my lord, instead of referring matter to the government level for appropriate decision,
Yes.
for appropriate decision whether the government would like to acquire this land or whether government doesn't require this land. Instead of that one, director directs the deputy commissioner, you adjudicate the matter, you decide the ownership of the land, my lord, which is not permissible under the law, my lord. Because, my lord, when there is a claim, my lord, and this is not the government land, my lord, because it is on the record, my lord, then the ultimate process is that it has to be acquired, my lord, lawfully. Then, my lord, tomorrow, my lord, this ownership, suppose, my lord, if anybody objects or anything comes up, then there is a, my lord, mechanism is provided under the act, my lord, how to resolve those issues, my lord. But the first, initially, the government has to satisfy, my lord, how they have derived the title of this land. And the law says that by possession, you cannot derive the title. You have to follow the law, my lord. This is my case, my lord. And once they fail to establish their title by following the due process of law, my lord, they are bound by the law, my lord, they have to follow, my lord. They are the state, my lord. Being a welfare estate, my lord, they have to be fair, they have to be fair. Fair to the public, to the people, my lord.
How many petitioners?
My lord, 4, my lords, and 5 is the, my lord, power of attorney, my lord. He is an educated person, that's why he is doing the work, my lord. So for 4 is concerned, they are the villagers, my lord. And my lord knows that in the state of Arunachal, all these lands which are not acquired by the government, it belongs to the public, my lord. This is the Land Record Act says, my lord. Section 2, definition, section 9, it says, my lord. Because the statutory presumption is that the land belongs to the people. Yeah, similar nature of case in Manipur also, my lord, passed by this Manipur High Court also directing Assam Rifle and state government to carry out the process of acquisition, my lord. In that case also, same issue, my lord.
What is this office memorandum 16/6/2022?
My lord, page number 16/6. 16/6, page 65, 60. Yes, my lord. This is the, my lord. When the, my lord, report was submitted to the director of the land management, my lord. Director of land management, my lord, instead of forwarding the matter for appropriate decision to the higher authority, my lord, remanded back matter to the deputy commissioner, saying, my lord, you are requested to the executive matter on priority and determine the ownership of the land in question, giving the petition. Now this has been impugned, my lord. This ownership, my lord, deputy commissioner cannot decide, my lord. Because section 9 of the Arunachal Pradesh Act doesn't say that deputy commissioner has a right to decide the ownership, my lord. How the deputy commissioner can decide the ownership, my lord?
Page number?
Page number 65, my lord.
16/6.
And and my lord, deputy commissioner being a party, he himself being the party, my lord, the government, he cannot be the judge in his own case, my lord. And he cannot decide that issue, my lord. So this has been also put into challenge, my lord. The matter should have been, my lord, forwarded to the appropriate authority, competent authority at the government level, my lord, to decide, my lord, whether they want to proceed ahead with the acquisition or they doesn't want to acquire this land for the public purpose. They don't require, my lord. That decision has to be from the appropriate authority.
And where is this 26, 10, 2020, annexure 3 page?
Annexure 3, my lord, page 62 to 64, my lord.
This is letter to the director.
My lord, this is the letter to the director by the deputy commissioner. My lord.
What has the deputy commissioner said?
My lord, may I take to page number 63, my lord?
Yes.
It reveals from record a district that the land allotted to the Assam rival was neither acquired by the government of Arunachal Pradesh, nor any gift deed agreement was executed with Assam rifle by any tribe residing in the district. However, further examination of the case required to conclusively establish the process under by the then government officer to allot the land to Assam rifle. Thereafter, my lord, may I come to my lord 1, 2, 3, fourth paragraph, my lord.
Yes.
On perusal of the reports, findings of the board members, it is found that the Assam rifle is in occupation of the area since 1952. The formal land allotment to them was done by the government of Arunachal much later. Initially, 342 acres of land was allotted to them by the Department of Land Management by order. And subsequently, 77 acres was also allotted to the Assam rifle by the communicated by so and so. And the Assam rifles are paying so and so crore to government of Arunachal Pradesh. However, there is no record available at the disposal how the land was acquired by the government for the establishment of cantonment for Assam rifle. There is no record of any gift deed by any native of the district or any records of land acquisition process under Balipara, Tirap, Frontier, Jurisdiction, so and so. The board also opined that whether due process for the establishment of cantonment was followed or not is not clear as major document filed so and so. Now thereafter, the reasoning, my lord, these reasonings are fallacious and unreasonable, not acceptable, my lord. The reasoning, those are the grounds whereby my claim has been rejected, my lord. Now it's saying that as per Limitation Act 1963 under section 25, 30 years period to claim ownership by possession by the so and so, my lord. Now, my lord, this cannot be, my lord. And moreover, my lord, one thing is there, it's so apparent and clear, my lord, that a deputy commissioner cannot take up the matter to decide the ownership, my lord, because it doesn't have that authority, my lord. Only the.
So both these letters are a decision on the ownership.
My lord, decided ownership, my lord, despite.
No. Annexure 3 and 4 is a letter deciding the ownership.
It's saying, my lord, that as per limited, petitioner has cited the so and so Manipur case land or so and claimants are unable to give any conclusive evidence of possession of land prior to and merely.
Who is the claimant? You.
Yes.
Okay.
Assam rifle has been paying so and so to be paid forwarding along with findings of my lord. He my lord only made observation. Now no concrete decision has been given saying that it needs further examination at the higher level. Thereafter, he forwarded the matter to the director, my lord. The director of land, my lord, instead of forwarding the matter to the appropriate level, again directed the deputy commissioner saying, you decide, my lord. So, my lord, once if it is admitted that this is not this land has not been acquired in the manner known to the law, my lord, then, my lord, things is there, my lord, they have to follow the law, my lord. This is basically some substance of my case, my lord.
Then next is 29/12/2022, annexure 5.
Yes, my lord.
Page number?
This is the impugn order, my lord, page number 67, my lord.
No, all these are impugn order.
Yes, my lord. Yes, sir. These all are impugn order. I have challenged all the order.
Page number?
Now, page number 67, my lord.
67.
Now, it's very interesting, my lord. Now, here, my lord, I am challenging. It's contradictory, my lord. In other impugn order, he is saying that no consent were taken of the villagers, my lord. No acquisition, not donated, my lord. Now, in this impugn order, now deputy commissioner will make a different statement, my lord. Now, deputy commissioner will say, my lord, B, reasoning B, my lord, page number 67, B.
Yes.
While declaration of township, the consent of fringe villages are duly taken, which speaks for the fact that villagers have given their consent at the first hand. Moreover, the subject land has been lawfully allotted to Assam Rifles so and so as per relevant provision of so and so. Therefore, The question of ownership in this case prima facie appears to be in favor of the government, owing to the subject land being consented by villagers at two instances. Firstly, at the declaration of reserve forest, and secondly, at the declaration of township area. Why this reasoning is wrong, my lord? First, my lord, this is contradictory to his own observation, my lord. He made in the earlier impugn order as well as the observation of the board, my lord. A board was also constituted, my lord. Report is here, annex, I have annex, my lord. Board said, my lord, that no process has been followed, no donation, no gift, no consent. So if government wants, government has to follow the due process of law. Now the deputy commissioner is saying that consent was taken. Now deputy commissioner is saying at two occasions. My lord, why this is not acceptable? First, my lord, at the declaration of reserve forest, my lord, notification is there, this particular area, my lord, the area under the possession of the Assam Rifle, that has been excluded, my lord. That is on the record. That has been excluded, my lord. Now, my lord, if it is a reserve area, then question that the government cannot also claim that this is a government land also, my lord.
The DL also has correctly said, ownership may be legally decided through.
My lord, this is also how that can be, my lord. That cannot be, my lord. And subsequently, my lord.
We are also going to do that. Yes. Question is whether should we do it today or after you file an affidavit contesting the case?
It is up to the petitioner, which way they want to end the case
No.
quickly.
Petitioners have argued the case.
Yes, my lord. My lord, here, to some extent, I will agree with the submission made by the petitioner.
Which
That to the extent that the deputy commissioner or the ADC could not have decided that.
No, this we will interfere with.
Yes,
We will say that.
Yes,
These letters will not come in the way.
yes, my lord. That is exactly why sometimes when this honorable court directs to dispose of the representation, these sort of things starts, my lord. This also earlier round of litigation, they prayed for disposal of the representation.
There was other litigation.
Yes, my lord.
Yeah,
Therefore, this
that is why.
That was for that was initially
to
direction
dispose of
to
the
the representation.
It has to come back. It has to come back to the court.
That's why.
That is why the Supreme Court in 2019 itself said, don't pass such kind of order. Because it does not solve the problem.
No, my lord. That order was necessitated because ADC was sitting over the representation. So some decision has to be made by the authority, my lord. And pursuant to that decision or direction passed by this honorable court only, my lord, that ADC has come with the report, my lord. Then committee was formed, my lord. Then subsequently this impugn order has been passed, my lord. Yeah, my lord. Which says, my lord, that in such case, my lord, when the government has not followed the law and taken the land, my lord, then, my lord, that my lord,
is
not
another
the
thing to
remedy
say
is not,
that
my lord,
whether
that
it's a government land. even if he can prove that government has not acquired the land, but it does not also prove that he is the owner of the land. First of all, he'll have to establish.
First thing, my lord, here is the question. First, admitted position is the government has never acquired the land, my lord. What is the government land, my lord? Section of the Arunachal Pradesh Land Record and Settlement Act speaks about what is government land. My lord, may I take to this section? My lord is disposing the matter.
Yes.
Oh. Then, my lord, may I take to the, my lord, some provisions, my lord.
Yes.
My lord, section 2. H.
This writ petition has been filed with the following prayers. For the prayer portion.
My lord, I will concede to this prayer 3, 4, and 5, or
Yes, 3, 4.
annexure 3, 4, and 5.
And do they have a right to insist for an acquisition of land? Nobody has
Exactly.
right to insist for
Acquisition of-
acquiring their land.
Yes,
Even if you have the land with you,
yes,
you can't say that you acquire my land.
yes.
No,
my lord.
then, my lord, my another submission would be, then is there government has the authority to forcefully take my land?
No,
No, that is also under challenge, man. It is not only I am saying, okay, don't acquire. I am not saying you acquire. I am giving the opportunity to the government. If you don't need for public purpose, don't forcefully take the land. Or if you want for public purpose, I am not saying you do. I am saying you make the decision. Because I don't have a fundamental right. At least I have a constitutional right, my lord. You have to follow the law.
Any other submission?
My lord, this is one submission, my lord. So here is the case, my lord. Admittedly, there is this is not a government land. This is not acquired, not donated. This is on the record, my lord, admitted position. Now, when the process has not been followed, how this has become the government land? Number one. Now, my case, my lord will see that some judgments, my lord. My lord, if one, I may place some judgment.
Yes.
2000 Vidya Devi case, my lord. This is not my case. I am forcing them to acquire the land. My case is that how you are in position, how you can allot my land without acquiring in due process of.
That, Mr. I have heard you.
My lord, para 12.2, my lord.
Article 300A of the Constitution,
My lord, my
court is well aware of.
My lord, 12.2, my lord.
Yes,
Then, my lord, this is constitutional right. I will not.
yes.
Then 12.3, my lord. To forcibly disposes a person of his private property without.
Article 300A of the Constitution has been elevated to a human right.
Right, my lord. Those things are there. There, my lord, in this case, now 12.7, my lord.
Yes.
Page 574. In this case, the applicant could not have been forcibly disposed of her property without any legal
See,
sanction.
Where is the forcible disposition of your land by the Assam Rifle authorities?
Now, question is that
Your one statement at paragraph
temporarily allowed,
4 and 5, which I'll be quoting in my order.
my lord.
You have temporarily
Allowed. Now, that's why I'm saying, since I have temporarily allowed, you cannot allot. That's why my allotment has been challenged, my lord. Since you are not the owner, then you cannot allot, my lord. Temporarily allowed, my lord.
Yes.
Then this is on this line itself, my lord. In a democracy governed by the state could not have deprived city without sanction of law. 12.9, my lord. Reliance is placed on the judgment of this so and so, where it was the state must comply with the procedure for acquisition or anything permission. The state being a welfare state governed by the rule of law cannot arrogate to itself a status beyond what is provided by the Constitution. Thereafter, the 12.11, We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for over 42 years, it would amount to adverse possession. The state being a welfare state cannot be permitted to take the plea of adverse possession, which allows a trespasser, a person guilty of so and so, my lord. Then, my lord, this is judgment basically, my lord, for after 42 years. Here also, in this case, my lord, already possessed, my lord, already taken possession. After 42 years, my lord, the state agitated a matter saying, no, after 42 years, you cannot raise the plea. Similarly, my lord, in my case also, Deputy Commissioner said, my lord, you cannot raise the plea since it's Assam Rifle has been, this is basically what the respondent is saying. My lord. So, Apex Court said, my lord, no, so far, this property is concerned, my lord, being a welfare state, my lord, you have to follow the law, my lord. Then, my lord, Manipur High Court, my lord, one judgment, my lord. Paragraph 8, my lord. Similar nature. Here also, my lord, Assam Rifle, my lord. Para 8, my lord. It is the state government who knows the law of the land better than anyone. Therefore, when they did not raise any question on the ownership over the land occupied by the Assam Rifle, there is no need of having any doubt on that point. As such, there is no need of going any further on the issue of ownership of land occupied by Assam. Since there is no more question on the ownership of the land occupied by Assam, the petitioner and his villagers are entitled to compensation for the same. Mere giving of no objection certificate to occupy the land will not disentitle them from getting their due compensation for their land. The government which exists for the people must not deprive landowners from getting their due compensation for the land which belongs to them, but is utilized for public purpose. In other words, though private land can be acquired for public purpose, a right guaranteed by the Constitution. Therefore, when the land belonging to the villagers was taken by the Assam Rifle, the state government should have immediately proceeded with the process of acquiring the same under the Land Acquisition Act. Having not done so, has compelled the petitioner and villagers to approach this High Court. Ignoring the rightful claim of the helpless villagers will only aggravate their grievances and suffering, which may in turn lead to erosion of their trust on the government. The issue as to who will pay the compensation, so and so, my lord. Then, my lord, I have annexed one judgment of this honorable court itself, my lord, in respect of Alo town area, my lord. My lord, it starts from, my lord, page number, my lord, 117, my lord. Annexure 16. Relevant paragraph, my lord, I will read, my lord. Paragraph, page number 125, my lord. Para 10, my lord. In the instant case, the aforesaid land is the community land of the aforesaid villager, and it cannot be said to the government land within the meaning of law prevalent in the state. The findings of the Deputy Commissioner alone clearly disclose that the said land is a private land of the aforesaid village. The fundamental question that if a person does not have a right over property, he cannot dispose the same in favor of. He cannot give more than what he has got. The land in question is being the land belonging to the effort. The state does not have any power or does not have any right to allot the same in favor of the army authority. The government has also so and so. Thereafter, my lord, paragraph 11, my lord. Government has also taken a policy decision to regularize the unauthorized occupation so and so, which also provides that such regulation of can be made when occupied personnel. Thus, the respondent have not been able to show that under what authority they allotted the aforesaid land in favor of the army without army authority, and on the face of the materials on record, the said land belongs to the aforesaid village. It is apparent for the order dated passed by the date. Sketch map showing the boundary discussion between the so and so is required to be prepared basing upon the above condition. The submission thereafter, my lord. Para 12, my lord. Now the question arises as to whether government had got any authority to the land in favor of the army authority. The establishment of the army authority headquarters is inter alia for public purpose and for the security of the country. And such authority, when require any land for their use, the same is to be provided by the state government. But in doing so, the government must follow due procedure of law. The government could have acquired the land of the petitioner's villager under the provision of the land acquisition army authority have so and so, as per the terms and condition of the alleged allotment order by error so and so and so. It is open to the government to acquire the land in question from the petitioner village, paying them due consideration. Thereafter, my lord, para 9, my lord. Here discuss about what is government land, my lord. I have considered the rival submission made by the parties and also perused the pledging of including the connected documents of material. Admittedly, the aforesaid land in question belongs to the villager of so and so. In 1962, during the Chinese aggression, the people of the said village allowed the army brigade to stay temporarily on their paddy land for the national security reason, my lord. It was in 1962, my lord. The villagers temporarily allowed. After the Chinese war was over, the petitioner had approached the concerned authority for vacating their land from the said army authority. It is also an admitted fact the land which falls within along township area has been donated by the villagers, said villagers. The question being having arose about the boundary of the along township as well as the land of the aforesaid village, it was finally decided by the deputy commissioner by so and so, so and so. The aforesaid order clearly discloses that land in question is a private land of the petitioner and it has not been donated by them to the government. In Arunachal Pradesh, government used to get land either from donation or by an acquisition. Section 9 of the Arunachal Pradesh Land Settlement provide so and so. So, my lord, this basically says that only there is two mode how the government can get the land, my lord, and other mode is not there. This is on that line, and my lord, it's almost similar nature of case, my lord. So direction was issued, my lord. If required, they can proceed ahead with the acquisition process, or if not required, my lord, it was temporarily allowed. Now you cannot allow and you cannot take the revenue, my lord. Now government is what doing. It was temporarily allowed. Now government saying this is our land. Now allotted, taking money from the Assam Rifle, my lord. So this is my grievances basically, my lord.
Miss,
If your lordship permits, I will give your lordship the copy. And then if needs be, I will file the additional affidavit as well later. For your kind perusal, I can furnish the copy to your lordship today after some time.
you may file a fresh petition as well after withdrawing it.
Lordship,
Yes. You may file a fresh petition also after withdrawing it.
no additional affidavit, I will. Is it possible, like if I file the additional affidavit with the contract agreement, then it may be will be part of the record of the petition.
How do we issue notice in the additional affidavit?
And notice may be issued after the additional affidavit.
Hard miss. Your good name?
P. Swargyari.
That is the instruction you have received from your senior.
Yes, and the copy is also being brought by the department right now at the moment from Nahar Lagoon.
Your good name?
P. Swargyari.
You. T?
P. Swargyari. S.
You are CGSC?
I'm not the CGC. Mr. S.K. Medhi is. I'm
Okay.
junior associate.
You give your name.
Okay.
So and so for Honorable Counsel for the petitioner. This is an application under section 11(6) of the Arbitration and Conciliation Act 1996 for appointment of an arbitrator. Post of on perusal of the arbitration petition. Agreement between the parties providing for appointment of arbitrator in the event a dispute arises have not been annexed. Full stop. In view of the above, this arbitration petition is disposed of with a liberty granted to the petitioner to file a fresh arbitration petition if so advised, annexing all the relevant documents for adjudication of an application filed under section 11(6) of the Arbitration and Conciliation Act 1996. Yes.
Obliged.
My lordship. Lordship, I have three grievances, lordship. Firstly, the respondent authority has wrongly calculated my pension, lordship. And the second, lordship, ACP was not included in pension paper, lordship.
What is this matter about?
Lordship, retirement benefit, lordship.
Retirement benefit.
Yes, lordship. Lordship, initially I was appointed as a driver in the Department of Industry on dated 15/1/1987.
When did you retire?
Retired, lordship, voluntary, lordship, on
Voluntary.
voluntary BRS on 01/2/2008. Annexure for page 32. Page 32.
You are receiving some pension.
Yes, lordship.
You want an enhanced pension.
Enhancement, lordship. Basically in great fair, lordship. Kindly, lordship, see the.
Have you filed representation?
Yes, yes, lordship.
Where is that?
Page 50. Page 52 is the latest representation, lordship. Annexure
Page
14.
52.
52.
How you are entitled for enhanced pension?
Lordship, kindly see, lordship. There is one OM, lordship. Page 33, lordship.
Page 30?
3, lordship.
33.
OM issued by the Government of India Ministry of Personnel Public Grievances. dated 24 March 2009.
Issue notice,
Yes, yes.
what Mr.
L1 Lordship.
L1. Counsel for the petitioner. And you speak one more.
All the respondent, my lord.
For all the respondents. No issue notice. Returnable in 6 weeks. Extra copy.
All right.
Yes, what is the matter about?
Lordship, it's
You don't remember. If
service
you have to
matter.
read, then you have to wait.
Actually, it's service matter.
Service matter.
I am referring on behalf of K. He is under medical treatment. His leg is fractured.
Huh?
He is under medical treatment. His
Medical treatment.
yes, Lordship. His leg is fractured.
Okay. What is the matter about, Miss?
Yeah, here, Your Lordship, the petitioner is challenging the termination order, Your Lordship, passed by the superintendent engineer,
Okay, all right.
PWD.
An adjournment has been sought on behalf of Mr. K. Lola, and the counsel for the petitioner, who is stated to be who is stated to be indisposed. When? After 4 weeks?
3 weeks.
3 weeks. As paid for, listed of 3 weeks.
Deeply.
May I plead my lord?
Yes.
My lord, this matter earlier, my brief was misplayed, my lord. So again, I have often throw this Xerox, my lord. Again, it is kept with my junior, who I supposed to affair today. But wherein last night, he had got some accidents also.
That
So-
indicates that
Sir, my lord,
you have no merit in this case.
so my lord, here in this case, the respondent has filed their affidavit, my lord.
What is the matter about first?
My lord, this is challenging the retender.
Retender.
Yes.
It has become infructuous.
Uh,
There is stay order.
My lord,
It has become infructuous.
Infructuous.
There is no stay order. That is why your brief is also not supporting you. Can we close it?
yes, my lord.
Yes.
It's a matter of 2022, my lord. And this was meant for COVID.
Since this writ petition pertains to, since the writ petition was filed, since the writ petition was filed in the year 2020 challenging the retender.
Yes.
Yes,
tender,
right.
that's a 28th August 2020.
Retender notice dated 20th August 2020.
Alleging that
Issued by the Secretary Health and Family Welfare, Government Anusal Province, wide number COVID-19 stroke MDev Capital Development, this MDev 43 stroke 2020 at page 21. While the council for the party submits that the petition has become infractions. In view of the rule, the petition is status. Disposal is infraction.
Obliged, my lord.
We'll come back after 5 minutes.
A. Bhattacharjee. Your Lordship, my learned counsel is in another court. I would like to mention item number 3. The matter may be please list for 3 weeks. After
What is-
3 weeks,
What is the matter about?
it's about service matter.
This matter.
Yes, and my learned counsel is also taking concern from another party.
Oh, major punishment, termination. Okay, all right. On the prayer of Mr.
A. Bhattacharjee.
No, you are not able to say.
Yeah,
What is
D.
your name?
Mara, Lordship. D. Mara.
D. Mara,
Yes, Lordship.
learned counsel for the petitioner. Please sit after
3 weeks, Lordship.
3 weeks.
My lord, in this matter, the respondent number 1 has not filed their reply.
One has not filed. What is this matter about?
My lord, this is about payment of admitted bill, man.
Oh, bill, not
Bill,
payment
yes.
of a bill.
And my lord, moreover, we want to file a rejoinder.
Who is respondent number 1?
My lord.
My lord, otherwise there is nothing also. Yes, the respondent number 4, he prepare one additional estimate for construction of some tourist lodge at Ganga Lake. On the basis of that additional estimate, he is claiming a pending bill. It was neither approved nor any sanction was granted.
Yes, which bill has not been paid to you?
My lord, we have constructed the tourist lodge at Ganga Lake, my lord. And for that, they have not paid the bill. my lord.
Where is the work order?
Work order, my lord.
$38,67,000. Where is the work order and where is the bill prepared? And the admission?
My lord,
Yeah, you will also point out.
Yes, my lord, in any case, my lord, this issue has been decided by this court, my lord, wherein in 2016, my lord. Wherein on being devoid of merit, this was dismissed and the petitioner was directed to approach the appropriate court, my lord.
Where is that?
That is at operative portion is page 16, my lord, of the of my
16.
affidavit in opposition.
Okay, just WPC
WPC
354.
354 of 2016. Instead of filing this appraise, my lord, they ought to have approached the civil court, my lord. If there is anything payable to them.
Is it correct, Mr. Tarak?
Otherwise, RWD in this case, Poma division prepare one additional estimate only. Yeah, the court has already passed.
My lord, may I read the operative portion of the last order, my lord?
Just a moment. Let us see his prayer cost.
Yes, his prayer, in their prayer is for payment of pending admitted pending bill.
Details of which are mentioned in paragraph 5G. Details of which are regular measurement.
If anyone has to pay the admitted bill amount.
They have not said anything. Details of which are fully mentioned here in above that paragraph 5G. Okay, 5G. 5G. Where is that 5G? 5. Therefore, in view of the details of the additional contract work at Ganga Lake, which are restaurant. 4,000. Okay. What is your response? To 5G, 5G, 5G. You have said no comments.
No.
Huh?
My lord,
Who is respondent number 5?
4, respondent number, no, I am respondent number 4.
Who is respondent number 5?
5 is Principal Chief Conservator Forest.
Okay, who has to pay the bill? Oh, 5 is a pro forma.
Performer respondent.
Tourism, I think tourism is to.
Tourism is the main.
My lord.
Okay, you are respondent 3.
Yes, my lord, lease agreement was, my lord, made between the parties, my lord. But after expiry of the lease agreement, my lord, he claimed to have executed some work without any authority, my lord. And against that, he is claiming some bill. And in the agreement itself, my lord, there is a clause wherein it has been mentioned that the lease agreement cannot be extended, my lord.
Art Mr. N. Singhi,
is my lord.
counsel for the petitioner, and who are the GHA for 1
And 5.
and 5 and
My lord, one has not filed the affidavit.
no, she is representing 1 and 5. And Pada for the standing counsel for tourism department for 2 and 3. And Mr. G. Tarak, standing counsel RWO for 4. R4. You have also filed affidavit.
Yes, Lordship, same here. Lordship.
That is respondent number 5.
Yes.
Okay. 5 will not say anything about 5G. Paragraph 5G.
5G, Lordship.
He has said, okay.
The respondent tourism have said.
All right, all right.
People see at para 8 here, para 8.
My lord, we want to file a rejoinder.
What reason? Nothing.
My lord, I have instructed this one.
You may be instructed, will not allow you to. This is
Otherwise, this, my lord, this case is liable to dismiss on
cost.
with cause.
My lord,
Abuse the process of the law.
my lord, my senior is in other court, my lord. May I call him? This matter may be passed over.
You call him in the meantime, will dictate the order. Yes.
Okay.
Call him.
Okay.
This writ petition has been filed. Taking payment of a sum of rupees 38, 67, 425. Stated to be payable to the writ petitioner
My lord, he is engaged in other court.
on account of the additional contract works. You forget this stated to be payable to the payable to the writ petition on account of the additional contract works.
My lord, my humble request. Kindly pass over this meeting.
The details of which is stated to have fully mentioned in paragraph 5G of the writ petition. Full stop. Paragraph 5G reads as under what 5G. Full stop. The respondent number 3 has filed a counter affidavit wherein the evidence made by the petitioner in paragraph 5G of the writ petition has been answered in paragraph 8 as here on the quote paragraph 8 of affidavit in opposition by 2 and 3. Oh, 2 and 3. Huh? No, not only 3, 2 and 3. Mr. On perusal of the contention raised by the writ petitioner is stated in paragraph 5G of the writ petition, comma quoted here in above, is that the writ petitioner had executed additional contract works mentioned therein, for which he is entitled to be paid 38,67,425. To the above amendments made by the writ petitioner, the respondents were 2 and 3 in the counter affidavit 5, which has also been quoted here in above in paragraph 8 thereof. As stated, that the construction stated to be undertaken by the petitioner must have been undertaken and carried out by him from his own resources and at his own capacity. Full stop. The Department of Tourism had never approved and asked the petitioner to undertake any such construction. Also, in view of the above, it being the federal position of law that read court in so far as the payment of bills are concerned can be entertained only when such a bill is admitted by the respondent authorities. Also, in the instant case, there being no any such admission by the respondent authorities, rather a specific denial made by the respondent authorities in the contractual file to the extent that the Department of Tourism had not authorized the petitioner to undertake any such construction. This there's no merit in the writ petition and the same requiring any interference by this court in exercise of the power on Article 2000 Constitution, and same is therefore dismissed, and same is therefore hereby dismissed. Without, however, any order as to cost.
My senior is engaged in other court matter. That's why he's now he's attending the court matter right now.
We'll hear him, let him come. If we can change the law, then
Yes,
we'll change the order.
Yes, ma'am.
Okay.
Sure. Obliged.
Yes. Yes. None appears.
None appears, my lord.
What is this?
In fact,
2014 matter appears.
yes. In fact, on 2 occasions, my lord, the matter was dismissed for non-prosecution, my lord. On 22/6/2022 and 16/2/2023.
22?
6/2022
2006,
and 16/2/2023.
22, 22, 6. And another one,
And 16/2/2023.
none is appeared for the petitioner, heard Mr. R. Sekhi, learned counsel for?
Respondent, my lord.
Oh,
Informative
Apik,
counsel.
then standing counsel for Apik. This writ petition was dismissed for default and non-prosecution on 2 occasions. I 22/6/2023. And and 16/2/2023. Post note. However, on an application filed for restoration of the restoration of writ petition and argued by Mr. S. Biswas, learned counsel for the applicant stroke petitioner on the writ petition was restored by an order of this court dated 24/8/2022 is 1/3/2023 respectively in the order passed in this case the MC 05 AP of 2022 and MC WPC 01 AP of 2023 respectively. However, in the proceeding held on 28/4/2023, Ms. M. Karwat, learned counsel, appearing on behalf of Mr. S. Biswas, learned counsel for the petitioner, had informed this court that Mr. Biswas would no longer be representing the petitioner in the instant case. In view of the above, no alternative arrangement that is found to have been made by the petitioner to represent the petitioner in the instant case. In view of the above, finding no alternative, this writ petition is again dismissed for default and non-prosecution.
Your Lordship, my senior counsel is engaged in a matter in court number 2.
6. Item 6 to 8.
Yes, Your Lordship.
Oh, you had sought for an adjournment.
Lordship.
What is the matter about?
Lordship, it's a promotion matter, Lordship. Petitioner,
From which post to which post?
Lordship, petitioner has been reverted back to trained graduate teacher to assistant teacher, Lordship, without issuing so much notice, Lordship.
Okay, this matter does not survive. Where is the education department? He is also not there.
No, Lordship.
Yes, can you tell something more about the case?
Lordship, this much only brief I have.
This is the opportunity for you to read the brief and come. Huh? If the senior is there, you will not get chance to argue.
Definitely, Lordship.
Huh? It is a golden chance when the senior is away. Okay. On the prayer of Mr.
K. Logan, Lordship.
K. Lolan, listed after a week.
Lordship.
We will perhaps we can dismiss this on that day. After a week.
Lordship.
God bless you.
Yes. Item number? Nine. Mr. Don.
Yes, ma'am.
Okay, yes, what is the matter about?
My lord, this writ petition is in connection with the promotion matter, ma'am, by superseding the senior, ma'am. And petitioner is senior.
Which post, which post?
And my lord, as per the affidavit of opposition being filed by the government, madam.
No, you first tell your case.
Yes,
Then we will go to the affidavit of opposition.
My lord, we have challenged the promotion of the private party, respondent number 3. As on the ground that they have not followed the recruitment rules, my lord, 2019, ma'am. And the recruitment rule we have annexed as a annexure one series, my lord, in page number 30, ma'am.
Just a moment. Huh?
And my lord, I have been appointed as a office peon, my lord.
Okay, yes.
Yes, my lord. My lord, may see the page number 36, my lord. As annexure 2, my lord. This is my appointment order.
Yes.
On 9th July 2013, my lord, I have been appointed as a office peon, my lord. And respondent has been appointed.
This is a regular appointment.
Yes, ma'am.
Regular appointment.
Yes, ma'am.
Office peon.
Office peon, ma'am.
Yes.
And comes under categorized as a MTS, ma'am.
And who is the private respondent?
Private respondent Krina Ishi, ma'am. Respondent number 3.
Respondent number 3. He was appointed when?
He was appointed on 23 November 2009, ma'am.
23 November.
23 November 2009.
2009.
Annexes annexure 9 of our petition.
Okay, page number?
Page number 45.
45. What is the seniority list?
My lord, seniority lists have been not been prepared by the concerned authority. There is no seniority list being maintained by the authority.
Not okay, not prepared.
Yes.
Then what happened? Yes.
Then, but what happened is then, my lord, by the appointment order date, by the order dated, my lord, 30 March 2021, page number 63.
Page number 63. Yes.
The private respondent, Krina Ishi, has been promoted as a LDC from the dark runner, my lord.
Dark runner.
Yes, ma'am.
Oh, he was a dark runner.
Yes.
You are a peon.
Peon, ma'am.
Okay.
And both the post comes under the MTS, ma'am. And accordingly, after the appointment, my lord, the private respondent has been transferred. Transfer order we have annexed on page 48, my.
He has been transferred where? Oh, Kamle district.
Yes, my lord. This is the matter of Kamla district.
Both of you were in Lord Subansiri district.
Actually, my lord, initially the private respondent was under the Lower Subansiri district and the petitioner was under the Kamla district, Upper Subansiri district.
Upper Subansiri.
Yes. After bifurcation, they have joined the, they are.
Oh, this, just a moment.
Yes,
8th July 2003 appointment is at Upper Subansiri.
yes, ma'am.
When did you come to Lord Subansiri?
Lower Subansiri, my lord, Kamla, my lord.
Oh, you came
As
to
we are,
Kamle.
yes, as we are the netizens of Kamla.
When did you come to Kamle? This private respondent is also in the Kamle.
Yes, my lord.
Okay. All right, all right. When did you come to Kamle?
My lord, as per the as annexure 6, my lord, page number 46, 42.
Give the date. Date
11 May 2020, my lord.
11 May 20.
Yes, my lord.
Page 46.
Page 42.
42.
Annexure 6.
Yes, Kamle. Then this private respondent was in Kamle from the very beginning.
Sorry, my lord.
Private respondent was in Kamle from the very beginning.
No, my
2009.
lord. He was also under the deputy commissioner of Lower Subansiri, my lord.
Okay.
Later on, he joined. My lord.
When did he come to Kamle?
That I have no idea.
Just a minute. You page 42.
42, my lord. This is order being passed by the deputy commissioner Daporijo, my lord. Along with me, other two others, other candidates had also been transferred to Kamla, my lord.
Yes. You are not aware of when the respondent number? Respondent
number 3, my lord.
3. When the respondent number 3 was sent to Kamle.
Yes, my lord.
Then what is your case?
My case is, my lord, as per the appointment record available with us, my lord. I am very much senior to the private petitioner, my lord.
Okay, because you joined in
2000, yes.
2033.
Yes,
He
my lord.
joined in 0 only on the year 2009.
9, my lord.
So you are senior according to
Yes,
you.
my lord.
So therefore you should have been.
Yes, my lord.
What is the rule?
That is my ground, my lord.
Okay. What is the rule for promotion?
The rule of promotion, my lord, we have annexed the annexure 1 series, my lord, from 30 to page number 34, my lord. Page number 30 to 34 is annexure 1 series, my lord.
What is the rule for promotion? Seniority or merit?
My lord, may come to the column that given in the page number 32, my lord.
Page number 32.
Yes, my lord. Column 10, my lord.
Yes.
Column 10, my lord.
Column 10, 25% of promotion from MTS
Yes,
through
ma'am.
limited department.
Yes, ma'am.
15% from skill continuation. 50%. Okay. There was an examination.
No examination. In affidavit in opposition of the government, they have admitted the facts that such limited departmental examination has not been conducted, my lord.
So it is also your contention that there was no examination. There has to be examination.
Yes, my lord.
This is also
Yes,
your
my
contention. Okay. Any other contention? No.
No, my lord.
Yes, Tapi.
If here is admitted that if petitioner is senior to the private respondent also.
Okay,
And as per recruitment rule, the promotion has not been done also.
okay.
That's, yeah.
That is the grievance.
Then Lazi, what to do? Huh? Both of you face exam?
Yes, we
There's
can.
no
put
other
the-
way, if that is the admitted position.
If examination is conducted, then the petitioner private respondent, other.
Others.
Other may be also get, yes,
Yes,
my lord,
yes.
opportunity to.
Till such exercise, my lord, I may be allowed to continue in the.
No,
post
why
because-
should?
Because my lord, I was given, promotion officially capacity only. It's the interim arrangement, my lord.
And you know, he's senior also to you.
Actually, my lord, in selection, it will not be purely based on the seniority, my lord. There has to be exam, my lord, on merit, my lord.
So
So those who will clear the exam, then they will become, it will not be purely based on merit, my lord.
you have a difficult case.
My lord.
All the difficult case appears to be coming to you this day.
Pardon, my lord.
All the difficult case appears to be coming to you these days. It is a difficult case to defend. Subject to what you say.
Yes, my lord.
So we allow the writ petition.
Yes, my lord.
It can be allowed, but since.
So let him remain for 2 months.
Sorry, my lord.
No, but it
Now,
will not be
Very good,
justified.
but
Things that, my
It
lord,
will not be
now,
justified.
my lord, now this promotion exam has to be conducted by the Arunachal Pradesh Staff Selection Board.
yes, that has to be done as per the
This,
recruitment rule, yes.
limited.
Yes, limited.
Yes.
Yes.
Permanent also.
Through APH.
And, since I was purely given officiating basis as an internal arrangement
No,
because.
officiating also you could not have them.
Yeah.
And then see, he has a better claim.
But my lord, the things that actually I was there from very beginning, he has come from the upper Subansri Raga. And the department, they are yet to finalize the seniority list of those MTS and all, my lord.
When did you come to Kamle?
Kamle, actually, right from the beginning, I was posted at the
No,
company
no,
only.
which is the date? Which is, no, though you may have been posted at
Kamle,
Raga, but
yes.
it was under the Lord Subansri.
Yes,
Yes, my lord. On the creation of my lord Kamle from
When
the
was,
very beginning.
when was it created? When was it created?
My lord, as per the record, it's annexure 6.
You give the date?
Yes, my lord, 6 August 2018.
Or 6 August 2018.
In annexure 6, my lord.
And seniority is inconsequential here. No? Everybody is entitled for participation in this quota. Third, Mr. T. Don, Learned Counsel for the petitioner. Mr. S. Kapi, Senior Government Advocate for Respondents 1 and 2. And Mr. D. Lali, Learned Counsel for Respondent number 3. Which respondent has filed affidavit? 2.
I'm representing 3, my lord.
3 has also filed affidavit. No, no. This petition is directed against the order dated 26 March 2021 issued by the Deputy Commissioner Kamle District Raga by number so and so at page 63, whereby the respondent number 3 has there's no mention that you are a dark runner in the page 63 order. No, Lazi?
Yes, my lord. Appointment order is mentioned here, my lord.
Have been appointed as LDC on officiating capacity. Full stop. The respondent number 3 is stated to be a dark runner. Full stop. Challenging the aforesaid order dated 26 March 2021, the petitioner contends that petitioner is the contents that both the petitioner and the respondent number 3 are multitasking staffs. Also, petitioner being appointed as the petitioner having been appointed, the petitioner having been initially appointed as peon by an order dated 8 July 2003, issued on 9 July 2003 by number page 36 by the Deputy Commissioner Dapurizo in the district of Upper Subansiri, and later on transferred to Kamle district on 11/5/2020, and on creation of Kamle district. Okay, on 11/5/2020, on creation of Kamle district in the year 2018, and respondent number 3 having been initially appointed as what the Dakarana page 45, no, page 45, having been appointed as
Yes, 45 please. Dark runner.
Yes, as Dakarana by an order dated 23rd November 2009, issued by the Deputy Commissioner of the district by number page 45. The petitioner is senior to the respondent number 3 in multitasking staff, though the petitioner, though the respondent number 3 may have been in the district of Kamle since 2018, which is the year of creation of Kamle district. Full stop. The petitioner further contends that respondent number 3 has been though has been shown as appointed in the impute appointment order dated so and so. The respondent number 3 has in fact been promoted in the post earmarked for promotion in the post has been promoted in the 25% of 25%, the 25% of LDC earmarked for promotion from MTS through limited departmental competitive examination in terms of the General Arunachal Service Group C, within bracket ministerial, within bracket common lower division clerk stock, lower division clerk come computer operator stock data entry operator recruitment rules 2019, page 30. Also. Accordingly, it is the further case of the petitioner that in an appointment made on the approximate 25% of the posts earmarked for earmarked for promotion from MTS through limited departmental competitive examination. The same is to be made after a limited departmental competitive examination is conducted. But in the instant case, the respondent number 3 was appointed by the impugn order of appointment that is so and so as LDC without conducting a limited departmental examination is provided under the relevant recruitment rules. That's the para. Respondent number 2 has filed, who is respondent number 2 has filed counter affidavit? Deputy Commissioner Kamle, Deputy Respondent number 2, the Deputy Commissioner Kamle District has filed a counter affidavit. Wherein it has not been disputed that the respondent number 3 was appointed as LDC by the impugn order without conducting a limited departmental examination as contemplated under the recruitment rule referred to here in above. Also, nor the respondent number 3 in the counter affidavit file has indicated that his appointment as LDC by the impugn order that so and so was made after holding a limited departmental examination as contemplated under the recruitment rules referred to here. In view of the above, admitted position that the respondent number 3 was appointed as LDC by the impugn order dated 26 March 2021 without holding a limited departmental competitive examination as contemplated under the recruitment rules so and so. The appointment of the petitioner, sorry, respondent number 3 is LDC by the impugn order appointed so and so is found to be not in accordance with law. Is found to have been made in violation of the recruitment so and so and therefore illegal. Under the circumstances, this writ petition is to succeed, and accordingly, this writ petition is hereby allowed and disposed of by setting aside the impugn order of appointment dated 26 March 2021, issued by the Deputy Commissioner so and so by number so and so, appointing the petitioner respondent 3 as LDC on officiating capacity with a further direction to the respondent authorities to take steps to hold to fill up the said post in accordance with rule so and so on, general so and so, as expeditiously as possible by providing opportunity of participation to all such candidates who may be eligible to participate under the rules. It is hereby ordered accordingly.
If my lord deem it fit, my lord.
Writ petition is disposed of, to the extent indicated and disposal. Yes.
If my lord deem it fit, my lord, as the private party through the illegal appointment, my lord, has it entitled with the surplus amount of salary, my lord. That may be recovered by the direction of this honorable court, my lord.
My lord, we'll not go to that extent. Okay. Disposal. Disposal.
Yes. Much obliged.
But your sentiment is justified.
Yes, yes, my sentiment is.
Yes, Mr. Sona.
Item number 4, my lord.
See, there's no admission. They have denied.
My lord, I have not prepared, my basically case is, my lord, that I need, because basically case is, my lord, principle of legitimate expectation and estoppel, my lord. These are the consideration have been considered by the apex law also, my lord. When the government does something or give assurance you do something, and on that basis, verbal assurance, even though, my lord, if a party does something and benefits is reaped by the government, then the my lord, fairness demands Article 14, my lord.
Here also you file a suit.
No, my lord. The law is there. My lord, of course, that suit is different issue. My lord, suit will come when there is a disputed question of fact so
see,
far.
You are seeking a mandamus
My lord.
for payment of rupees 38 lakhs.
My lord.
Now, law in so far as the mandamus vis-a-vis the payment of a bill is concerned,
My lord.
it is settled. It has to be, there has to be an admission in an unequivocal manner.
My lord, may I pray, my lord? I will today, my lord. I have not. I will my lord.
Just a moment. In your case, apart from you not showing any documents of such admission, they have filed a counter affidavit specifically denying.
Deny.
See, we did not authorize you. He may have forcefully constructed. Under that circumstances, how a mandamus can be issued? See, I'll tell you one case in 1997 where the chief engineer, that is Subhash project, chief engineer had made a categorical admission in the letter addressed to the Subhash project that such and such amount is admitted to be Uh, when do you want?
26.
Okay. Miss G. Ete, an additional senior government advocate, pursuant to Mr. Tarak and Pada have advanced the argument and they have uh, have been heard. You record his name as well as others. Learned counsel for the parties have been heard. Mr. G.A.T. and Father Tarak have concluded their argument. Full stop. However, Mr. Stoner, learned counsel for the petitioner, has prayed for one more opportunity to reply to the arguments advanced by the learned counsel for the respondents and press for listing of this matter on 26th. Yes. Listed on 26 for reply argument for reply argument by the learned counsel for the petition is instrument. That will be okay. Is not
Much of.
and that order will remain. Okay.
Lordship, Lordship, some more time may be given to file an affidavit in opposition filed by the respondent number 1 and 2.
10 is a contempt case.
Yes, Your Lord.
You said it has been complied with.
Lordship, can you see the judgment, Lordship? It page 12, Lordship.
12.
Page 12, Lordship.
Yes.
This is pertaining to pending bills, Lordship. And I'd like to take Lordship to 11 kV line from host to Yajali under so and so to the finance department within a period of 15 days from the date of so and so and so and so. Upon receipt of so and so LPC authorization proposal, the finance department shall give a due consideration it within the so and so. Upon necessary sanctions been given, the amount concerned be released to the petition within a period so and so. Here, Lordship, so far the allocations and the sanction is concerned, that has to be done by the finance department. Otherwise, this is the work is related to the power department, Lordship. And petitioner was awarded the work by the power department, and the amount also has to be released by the power department, Lordship. Now, the finance department, Lordship, has two sections, Lordship. One is the Lordship planning and investment, other one is the finance, Lordship. Allocation is done by the Lordship planning and investment, Lordship. The party who have been implicated here is a contempt Lordship, respondent Lordship. They belongs to the finance department, Lordship. Now the planning investment department has already allocated the fund, Lordship, and the finance department also has issued the sanction, Lordship. LOC has been given authorizing the power department to release the amount, Lordship. Now it's between the power department and the petitioner, Lordship.
Okay.
So present respondent, Lordship, 1 and 2, Lordship, they from the finance department, Lordship. Their part they have already done, Lordship.
Where is that?
Additional affidavit, Lordship. It was filed on 21st December 2022, Lordship.
By respondent number 1.
This is by respondent number 1, Lordship. Correct, Lordship. This is the principal secretary, finance department, Lordship. At page 4, Lordship, this is the allocations of fund by the planning and investment department, Lordship.
No, This additional affidavit is by Chukutajo.
Lordship, this additional affidavit was filed on 21st
By whom?
21st. This is by the
Chukutajo.
respondent himself, Lordship. Tara Chauhan.
Just a
It
minute.
was filed on Lordship 21st December 2022,
Okay, not the August.
not August, Lordship.
Then there appears to be more than one additional affidavit.
Yeah, one more is there. Okay. But the relevant, the latest one is
Okay, additional affidavit.
closed.
Correct, John, yes.
Lordship, we find the allocation made by the Planning Investment Division, that is at page 4, Lordship, annexure A,
Page 4.
Lordship. And relevant is at page 9, Lordship, at serial number 37, Lordship.
Page 9.
The total amount was for 3 crore lakh. And the rest amount was already released to the petitioner. Only the left amount was 1 crore, Lordship, 101.02, Lordship.
Okay.
And this was allocated by the Planning and Investment Division. Then thereafter, Lordship, LOC has been issued. Page Lordship 23 by the Finance Department. Then Lordship, bank has been authorized on Lordship 15 November 2022. Lordship, kindly see page 22, Lordship.
23.
Page 22,
22.
Oh, yes,
Yeah. This is the LOC.
LOC is at page 23. We have given to the Power Department, and Power Department has given this at page 22, Lordship, to the branch manager, State Bank, PSLA, Lordship. This is by the Power Department. And so far our part is concerned, the Finance Department, Lordship, we have already given the allocation. Sanction, Lordship.
All right. We close it.
Lordship, in this regard, I may be allowed to file an affidavit in reply in regard to the affidavit filed by the respondent 1 and 2.
In the contempt case?
Yes. They've already filed their affidavit in opposition.
Mr. This was filed on 7th of January 2023. Copy was served to you on 21st January. And we are in July. Mr. Council petition and recess council respondent number 2.
And 1 and 2.
1 and 2.
Close.
This contempt petition has been filed alleging violation of order dated 2/12/2021, passed in WPC 112/2021. Where in paragraph 7 and 8. This wherever executive engineer electrical Yazali electrical division was directed to submit the required proposal for the balance amount of the work construction of transmission line of 11 kV line from Hose to Yazali under BE-2019-20 to the Finance Department within a period of 15 days from the date of receipt of a certified copy of the order. Upon receipt of such LPC, it should be LOC, I think, huh?
This is LOC though. Page 22 is
No,
LOC.
not LOC. Upon receipt of such LPC, what is LPC? Upon such receipt of LPC authorization proposal. What could this?
It should be LPC law. LOC law.
Upon receipt of LOC authorization. Okay, you write upon receipt of LPC within bracket LOC. Can we write LOC?
LOC.
The LOC will come later. After finance department sanctions it.
Lordship.
You are a finance department.
Yes, I'm the finance department.
This can't be LOC.
LPC, Lordship.
But there can't be, it can't be LPC also. Is not it? Something is missing there. Okay, you write like this. Wherein in paragraph 7 and 8, it has been ordered as under code 7 and 8.
It can't be LOC those.
It can't be LOC.
It can't be
The respondent number 2 and 3. Both have filed affidavit or?
Both of them.
Sorry, 1 and 2, 1 and 2. 1 and 2 have filed affidavit. Poster. In the affidavit, in the additional affidavit filed by the respondent number 1 on 7 January 2023. It has been stated that pursuant to the direction contained in paragraph 7 of the order of policy quoted here in above, the respondent number 1 has not the respondent number, the finance department has by an order by a letter dated 21st June
On allocation.
2022 written to the Commissioner Power, Government of Itanagar, by the this is by the Secretary Planning and Investment, no?
Planning and Investment Secretary.
Okay, not the Department of Finance. By the Planning and Department, by the Secretary Planning and Investment, by number so at page 4 of the additional affidavit. Had allocated fund for plan activities and the budget estimates. Had allocated fund for construction of transmission line of 11 kV line from Hoj to Yazeli, EC rupees 3 lakhs. EC means is the estimated cost 3 lakhs. Number PWRS stroke EST dash 91 stroke 2019 dash 20 within bracket CEG dated 27/1/2020 at page 9 of the additional affidavit, payroll number 37 to the tune of rupees 101.02 lakhs, which was the balance amount. Full stop. Yeah, where is the act of the finance department? This is after approval of the finance.
After the budget, after the planning investment is allocated, Lordship, we have already given the administrative approval, Lordship.
Where?
To the that order is not here, Lordship. Thereafter, Lordship, we have given approval to the power department. Thereafter, the power department has also given the LOC at page 22.
No, where is your part? You are a finance department.
Lordship.
Where is your letter?
Lordship, the letter has not been annexed yet.
That is material.
But Yes, but we have given a statement and that kindly see
Where-
the
where?
page 22, Lordship.
Page 22.
Page 22 is the power department
No, that I've seen.
has
Where
given,
is your statement that you have given approval?
Lordship, see.
It is the finance department who approves first or it is the planning and investment?
Planning investment has to approve.
He has to approve first.
Planning and investment has to allocate the fund,
Hmm.
then administrative approval has to be taken from the finance.
Okay. Where has you been, what have you done thereafter?
Lordship, kindly see the paragraph 4 and 5. Lordship.
Paragraph 4. This is to submit once again. They could do this.
Paragraph 2 and 3. Lordship.
See, here what you say is, after the fund was allocated by the. Oh, this is one department or what?
Finance department is the one department. Lordship.
Planning and Investment Division of Finance.
Yeah, this the one, two divisions are there, Lordship, but
Planning-
one department.
So this letter is by whom? Is by the planning.
This planning and investment division, Lordship.
Of the
finance department.
There's no in the.
Department is one only, Lordship, but the two divisions are there.
Secretary Planning and Investment.
Investment.
Department of Finance, Planning and, okay. Okay. So this appears to be a consolidated order. Hereafter, finance approval is not necessary.
Approval is.
Where is that approval?
That approval, Lordship,
See, this department is Finance, Planning and
investment department.
Isn't it?
Yes.
According to you, after the fund is allocated by the Planning and Investment Department,
No,
then approval of the finance is required. Then it will go to the power,
no,
is not it?
No.
This is by the planning
Correct.
and investment.
No.
Where is your approval?
Lordship, in the third paragraph, Lordship,
That paragraph,
Third.
where?
third paragraph.
That paragraph of
This additional affidavit, Lordship.
counter affidavit.
That order has not been annexed, Lordship. So far.
Yes, let us see, let us read.
On receipt of the proposal for LOC authorization from Power Department.
No. See, this fund will go to the power department. Initiated by the planning and finance, planning and investment through the finance department,
No,
is not it? So where is your approval? So that it has gone to the power department.
Lordship, this only, Lordship, it's impliedly, Lordship, it can be.
No, it can't, there can't be implied. See, you are a finance department.
Correct, Lordship.
Planning has acted, power has acted, which you are saying, but you are not saying what you have acted. So we'll give, yes.
Yes, your lordship, some more
No,
time.
have you received the payment or not?
That has to be ascertained to my senior.
Used it after 4 weeks. As per progress, sir. Yes.
Hello.
Yes, you have to call the next case. 11.
Yes,
Okay.
lordship.
What is 11?
This is regarding the challenge of the order which has been passed by the ADCA. In this regard, the only ADC has been filed their affidavit. Remaining is still the.
Your Lordship, in this matter, Your Lordship, we have received instruction from the respondent number 5 to 10 civil supply, but incomplete parabase reply we have received. So Your Lordship, some more time may be needed.
What is the matter about?
Lordship, regarding the petitioner is then a registered fair price shop, which has been running since from 2017. And after 2017, some complaint has been made stating that all the beneficiaries which I had to be not supplying that on my fair price shop. Accordingly, they have made a complaint against me and made my fair price shop to convert into Ruxin Cooperative Society. This order has been passed by the ADCA. So in this regard, I'm challenging the order of the ADC which is passed against by me.
All right, how do we start? Council for petition and SP Pangu, government worker for which respondent?
1, 2, 3, 4, and 5, Your Lordship.
Who prays for and is granted 6 weeks time, further 6 weeks time to file counter this after 6 weeks.
Yes, Your Lordship.
Hello.
Yeah, madam, I have been requested by Mr. Kato that he will not be available today, madam. So, madam, can
You
you?
have got a petitioner?
Yes, madam.
What is the matter?
Madam, correction of date of birth, madam, in my service to madam.
Up to?
Well, after 3 weeks, madam.
Okay. The trailer was listed after 3 weeks.
My please, Lordship. In this item 13, respondent, they have not filed the affidavit yet.
What is the matter about?
This is regarding non-distribution of the compensation amount. Regarding NH 15 from the package C, that's a Bandadeva area, Karsingsa and Bandadeva.
Okay.
And this is especially, this is a totally, they have now diverted the road now to the blockage area. That area they have diverted to our land. So government has clearly instructed such cases compensation should be paid. And everything has been estimated. They even published that in the newspaper, you wait there, we are coming to distribute the amount. After that, the compensation has not been distributed.
2 writ petitions perhaps?
No, different 13 is different 14 is different. And 14 they have filed, the deputy commissioner has filed.
Here they have not filed affidavit.
Here the deputy commissioner who has not disbursed money, affidavit is necessary.
Oh, so grant them time.
We have received the instruction. So we have given 2 weeks time also.
The prayer of Mr. S. Senior Government Advocate, representing the Deputy Commissioner, who submits that instruction for filing of a counter affidavit has been received. 2 weeks time is granted for filing of a counter affidavit.
Other respondents, they want to file or don't, we don't.
Same order in.
No, I think 14 they have filed, deputy commissioner.
They have filed.
Yes, ma'am.
Then what is to be done?
Let the affidavit file in item 13, then it matter will listed together.
List it also, 2 weeks, allow it, publication. And 415.
Obliged.
Madam, the respondent is supposed to file affidavit in opposition.
Yes, what is the matter about?
Yes, my lord. The matter is regarding.
Gambura has been dismissed.
Yes, Your Lordship.
Yes. Yes, my lord.
Gambura has been dismissed.
Yes, my lord.
Yes.
Your lordship, some more time may be given, your lordship. We have yet to receive our Paravas reply.
Ms. Margie, the Legal counsel for the petitioner. And Ms. P. Pangulan, government advocate. Who submits she is yet to receive instruction.
Yes, your lordship, Paravas
She
reply
is
from the
yet to
department.
receive instruction for filing of the counter affidavit. And so in view of the above, 8 weeks further time is granted for filing of the counter affidavit. Interim order pass and shall continue till the next date of listing.
3 weeks may be given.
Why?
And
She has not yet received instruction.
Plus, your lord.
All right.
This is a fixed matter, can be
Yes.
heard and can be disposed of. Lordship, it's already a covered case, Lord.
What is the
It's
matter?
regarding, it's a pension matter, Lordship.
Gender matter.
Pension, Lordship,
Pension.
pension. I have retired in the year 2016. Lord.
Oh.
NOC regarding.
You will ask to
Yes.
find out.
Yes.
How many cases are there?
Only two, madam. This one and one more case,
Are you
madam.
sure?
Yes, madam. Regarding this NOC, madam.
NOC,
Yes, madam.
NOC, vigilance, etc.
Vigilance
Lord.
is different, madam. This NOC, madam, from the DC, madam. There's only one case, madam. That is petition number 323, madam.
Pension.
Yes, madam, pension. There's also some encroachment of government land, madam.
Okay. Which is the other one?
Petition number 323 of 2022.
Not listed today.
No, madam.
Okay. Only two, no?
Yes, madam.
Yes.
Lordship, in fact, I have annexed one judgment of this honorable court where entire thing has been dealt, Lordship. Page 44, Lordship.
Hmm.
45, third paragraph is the relevant, Lordship. Page 45, paragraph 45. Page 45, paragraph 3. A settled position of law that right to receive pension by a public servant has been held to be covered under the right to property, and accordingly, the same cannot be taken away except in accordance with law. The office order dated 6/6/2017 issued by Principal Secretary of Vigilance, Arunachal Pradesh by order so-and-so, as well as the official order dated so-and-so issued by Commissioner Vigilance, Government of Arunachal Pradesh, by order number so-and-so, not being a law, but merely an executive order which runs contrary to the CCS pension rules of 1972, of the view that the respondent authorities are duty bound to process the pension papers of the petitioner if the petitioner is entitled to a pension under CCS pension rules 1960. Same similar situated case. Lordship. Now, according to all those executive orders, Lordship, my NOC has been denied, which has been put to challenge, Lordship. Now, Lordship, and regard one more prayer I have in my petition, that is regarding the interest. Since 2016, I have not been paid pension. So with lot of hardship, I am surviving, Lordship. So
when did you retire?
2016, Lordship.
Yes, what? Which date? On which date? 31st May.
Lordship, yes.
From which post? Deputy Commissioner?
Lordship, I was serving as CHO, Lordship, Community Health Officer.
Community Health Officer.
Lordship, I was working in at a district hospital, Bombay, Lordship. West Command District.
And where is that order? Where, by which order your pension has been held up? Have you received any instruction in the matter?
Yes, madam. I have received instruction from respondent number 7, madam, from Deputy Commissioner, madam.
Yes, sir.
Page 39, Lordship, annexure series, page 39.
39.
Lordship.
Regarding NOC.
Regarding NOC relating to non-enforcement of law, so they have denied my NOC.
May 2018. You have been denied pension on the basis of 11th May 2018.
This is the order I have annexed, Lordship, page 40 and 41, Lordship. This is in fact the order copy of Secretary Vigilance, Lordship, page 40 and 41, Lordship. I have annexed, Lordship.
But in the earlier order, it refers to Office Order 6/6/2017. Letter is different. Issued by the
Lordship, these are all, Lordship, these are all connecting orders, Lordship.
Connecting orders.
One is, sir, initially in the year 2013.
Where is that order you are annexed?
Lordship, I have annexed entire orders, Lordship. Page 28 is the first order that was issued by Principal Secretary, Lordship. Page 28, Lordship.
28.
Lordship.
You tell this order also on 11 May 2018. Page number?
40, this 11 May is 40 and 41, page 40 and 41.
40 and 41.
Lordship.
Oh,
Order 11 May 2018.
Oh.
And two more orders are there, Lordship. Same connected, Lordship. Issued by Vigilance Department. One more is 6 June 2017, Lordship. That is at page 29. Issued by Principal Secretary and Vigilance. And one more is there, that is of latest one, Lordship. That is of 25th February 2020, Lordship.
Yes, what instruction do you have?
Yeah, my lord, I've received instruction from the Deputy Commissioner, my lord. According to Deputy Commissioner, my lord, that as per the standing order of government, my lord, this vigilance order, my lord.
Which order? That
This
is
page number 28, my lord.
28.
And it's 3, my lord.
28.
My lord, third para, my lord.
2nd April.
Yes, my lord. 2nd April 2023 or 2013, my lord.
Yes.
Yeah, my third para, my lord. May I read, my lord?
Yes.
To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance of government officials for promotion and for setting retirement due NOC shall be obtained from the concerned Deputy Commissioner, clearly stating that the government officials has not encroached upon any government property, nor has caused any damage or abated encroachment on the public property by a private person. According to this order, my lord, this NOC was not given because, my lord, he has encroached a land, my lord. Build a building also not there.
Your Lordship is aware that these are all the executive orders, Lordship. This cannot supersede the CCS rules, Lordship.
Anything else you want to say?
No, my lord. According to our instruction, only this much from this Deputy Commissioner, my lord. And vigilance, my lord, we have not received any instruction, my lord, yet.
How many notifications are there? Yes.
There are more than 4, my lord.
So in total, Lordship, I have annexed, Lordship. There are 4 orders.
What do you say? Yes.
My lord, my part, my lord, unless
okay.
the DC issues, my lord, this is the order of the authority government. If we violate this order, the authority concerned will be subject to disciplinary action under CCS.
All right, who represents Director Audit and Pension? You.
Yes, ma'am.
Mr. J. Lilly, counsel for the petitioner.
Lordship, one more small prayer I have regarding the interest, Lordship. I have some citations to
Interest.
place, Lordship.
Ah.
Regarding the interest, Lordship. Since 2016,
Okay.
my pension has been stopped
What is that?
due to all those executive orders, Lordship.
Ah.
So which is in violation of CCS rules, Lordship.
Okay.
So I have two judgments to place, Lordship. One would be regarding the how much interest I am entitled from the government, Lordship.
How much? How much?
12% per annum, Lordship.
12% per annum.
This judgment is of 1987, Lordship, for SCC 328, Lordship.
1987. Huh?
Only one small paragraph, Lordship.
Yes.
Lordship,
This para 24.
24, Lordship. Yes.
Okay. All right, we'll grant you that also. 24. Normally, this code as a settled practice has been making direction for payment of interest at 12% on delayed payment of pension. There's no reason why. Yes. Any other decision?
Lordship, one more decision I have regarding the interest and that has to be immediately after superannuation. From the issue was whether from the date of litigation or from the superannuation. This has been settled in 1987 supply SCC 556, Lordship. Page 56. Small judgment, Lordship. Para 2 is 11 paragraph. Hard both sides, page 56, Lordship. In fact, it is in page 57, Lordship, relevant paragraphs. Yes. Hard both sides, the High Court has awarded interest with effect from the date of institution of the writ petition instead of with effect from the date on which the pension and gratuity amount, etc., became due on his superannuation about 4 years earlier. The appeal is therefore partly allowed to the extent that the appellant will be awarded interest from the date of his superannuation in 1981 instead of date of institution of writ petition.
Have you encroached?
Lordship, my contention is for my petitions, Lordship. My contention is that lane.
You forget the interest part since you have encroached. This was not on an encroachment case.
Lordship,
you take the lane if they don't evict you.
Lordship, in fact, I am the one who is in occupation of that land, Lordship. It was my husband.
JJD for petitioner. Taun for R1.
3 and 6. 1, 3, and 6.
R1, 3, and 6. P1 for R2.
5,
4,
2, 5, and
5
2,
and
4, 5, and 7, mine.
4, 5, and 7. That's 5 and 7. The petitioner who had retired from service on attending superannuation on 35 sorry, 31/5/2016 as community health officer. Huh?
Lordship, yes,
From the office of the district medical officer, Bomdila,
District Hospital, Komdila.
or district hospital, Bomdila, has approached this court. Alleging non-payment of the pension to the petitioner. Purportedly on the ground that the petitioner has not submitted no objection certificate to the effect that petitioner has not encroached upon the government land as provided in the order dated 11th May 2018. Issued by the Department of Vigilance, Government of Arunachal Pradesh, by order number VIG-07/2018. As can be gathered from the letter written to the petitioner by the Deputy Commissioner West Siang District, West Kameng District, Bomdila. Letter dated, I said, 4th November, no? By number 8 page 39. Full stop. From the opposite letter, it further appears that the petitioner has been found to be in occupation of a plot of land at Medical Colony, Bomdila, without any allotment order from the competent authority and constructed a RCC building there. Also. When a counsel for the petitioner has submitted that petitioner's pension cannot be denied on the basis on the ground that NOC regarding non-encroachment of government land has not been submitted by the petitioner in terms of the letter dated 11 May 2018 issued by the Department of Vigilance, Government of Arunachal Pradesh, mentioned herein above. Also, the petitioner has also annexed various other notifications issued by the respondent authorities from time to time for denying pension of the employees who have retired on the grounds stated, which are the following. Order dated 2nd April 2013, issued by the Principal Secretary Vigilance, Government of Arunachal Pradesh, Itanagar, by number so and so, at page 28. Order dated 6 June 2017, issued by the Principal Secretary Vigilance, Government of Arunachal Pradesh, Itanagar, by number so and so, at page 29. Order dated 25th February 2020, issued by the Commissioner Vigilance, Government of Arunachal Pradesh, by number so and so, at page 30. And This is the last, I think 34 is the last.
One more is there, Lordship.
Okay.
11th May 2018. Lordship.
Then.
Page 14.
Next is order dated 25th February 2020.
2018, Lordship.
Huh?
2018, before 20, Lordship, there is 11th May.
No. 2018, where 2018?
40, Lordship, page 40, Lordship.
No, 40 will come to later. 25th, order dated 25th February 2020. Issued by the Commissioner Vigilance, Government at page 34. And order dated 11th May 2018. Issued by the Secretary Vigilance, Government of Administrative Service, by at page 40. Full stop. It is, I mean, just Miss Hugh. Now the counsel for the petitioner has contended that the pension of the petitioner cannot be denied on the basis of the opposite orders which are in the nature of on the basis of the instruction received from the Deputy Commissioner, Bomdila, has submitted that since the petitioner was found to be in occupation of a government land without any allotment, the petitioner has been denied his pension in terms of order dated 2nd April 2013, issued by the Principal Secretary, Vigilance Government by number 7. So either it was Mr. Pete Tagum, Standing Counsel for the Health Department, have submitted that the Health Department cannot violate the order issued by the various orders issued by the government referred to here in above, and it is precisely for that reason the petitioner has not yet been paid the pension. Upon hearing the London counsel for the petitioner, well, they just no. I have heard the counsel for the parties, and the materials placed on the court have been perished. It is we just from the submission made on by the government advocate Ms. T. Wangmo. It has been noticed that the petitioner, who had retired as community health officer on 31/5/2016.
Lordship, small correction, Lordship. Lordship, he retired on 1 July 2016, Lordship. I strongly
submitted. 1st July 2016.
From where did we get this
Lordship,
date? 31/5?
Lordship, I'll just show Lordship. Page 25, Lordship, annexure 2, Lordship.
Page 25.
Lordship. Second paragraph is the relevant one.
No, from where did we get this date?
Lordship. So
31/5?
that's what, Lordship. 1 July 2016, Lordship. He superannuated on 1 July 2016.
He superannuated on 1 July, but from where did we get this date earlier?
Earlier, Lordship.
31/5/2016.
From page 24, Lordship. His representation, Lordship. He's proceeding on superannuation.
You did not know, when did you retire?
Lordship.
It is projected. Wrongly it has been mentioned.
It's wrongly mentioned, sir. But then, Lordship, page 25, Lordship. In fact, in my petition also, I have rightly pointed out, Lordship. 1st July.
It is noticed that the petitioner who had retired on 1/7/2016 as community health officer from your district hospital, Bondila, has not yet been paid his pension on the ground of encroachment made by the petitioner. Has not yet been paid his pension on the basis of order dated 2nd April 2013. Issued by the Principal Secretary, Vision Government by no so and so, as submitted by the Lama Government Advocate P. Wangmo, on the ground that petitioner is found to be in occupation of the government land without allotment, and he failed to submit no objection certificate as contemplated under section as contemplated under order dated 2nd April 2013, issued by the Principal Secretary Vision Government of Andhra Pradesh. It is a settled position of law that the right to receive pension by a public servant has been held to be covered under the right to property in the inverted comma. And accordingly, the same cannot be taken away except in accordance with the law. The office order dated 2nd April 2023 issued by the Principal Secretary, Vigilance Government Honorable by number so and so, referred to by Ms. Wangmo, London Government Advocate, is an executive order issued by the Principal Secretary, Vigilance Government of Andhra Pradesh. Also, the payment of pension to the government servant in the state of AP, more particularly in the case of petitioner hearing, is stated to be governed by Central Civil Service Pension Rules 1972. Which is a statutory rule framed by the competent authority for payment of pension to the employee for payment of pension. It is equally a settled position of law that an executive order which runs contrary to the statutory rules. Cannot be enforced. Full stop. The order dated 2nd April 2013 issued by so and so. Right number so and so. Before that, cannot be enforced for the reason that such an executive order is not law, whereas the CCS pension rules of 1972 is a law. Most of it. The order dated 2nd April 2013. Therefore, order dated 2nd April 2013 issued to the Principal Secretary by number so and so, not being a law, but merely an executive order which runs contrary to the CCS pension rules of 1972. I am of the view that the respondent authorities cannot deny the petitioners his pension for the services he has rendered to the state on the strength of order dated 2nd April 2013 issued by the Principal Secretary from Vigilance so and so by number so and so. If the petitioner is entitled to a pension under the CCS pension rules of 1972. For the reasons stated herein above, it is equally held that the state authorities cannot deny the pension to the employees who have retired from service on the strength of you give all the notifications, all 5 notifications. If the retired employee is entitled to a pension under CCS pension rules or 1972 or any other statutory rules for payment of pension to such a retired employee. For the reasons and discussions made here in above, this petition succeeds and succeeds. The respondent authorities therefore are hereby directed to immediately process the pension paper of the petitioner and make payment of the and pay petition and pay pension to the petitioner. If the petitioner is entitled to a pension under CCS pension rules 1972 without insisting on adherence of any of the notifications referred to herein above. Notifications issued by the various authorities referred to herein above. No? Yes. Read petition is disposal with the income table.
Lordship, regarding the interest, Lordship, I had made some
No,
submission.
you are in encroachment. You are encroacher. None of this, huh? So this order will clarify, none of this will apply to the pension.
Interest is for man of deliberate negligence, but it's not a case of negligence on part of the state respondent. There's an order and it falls under that. That's all.
Delay on the part of yours, not on account of negligence,
My lord.
but on account of the wrong legal advice you have received.
My lord.
Yes.
Lordship, there are other remedies available. Even if I'm encroaching government's lane, there are other remedies available. They could have exercised those, Lordship, instead of that.
Now he
Insisting
is now telling you how to evict him by you. Yes.
All right.
What is this matter?
Petitioner challenging a decision passed by the executive magistrate long regarding the paternity of.
Of paternity.
Yes.
None appears for the petitioner heard Miss. Can it be disposed of?
My lordship, corresponding number 5, service report.
Okay. Heard. Miss K. Government advocate for this thing. List in the order. List it after 4 weeks.
Your Honor, my lord. My senior is now fight for a toilet, so kindly pass over the next.
Yes, Laji.
Sorry, madam. My lord, this matter is pertaining to sudden change of place of interview from state of Arunachal Pradesh to Delhi.
Who is for the respondent?
Respondent earlier, Mr. Ratan, and sometimes Mr. Katu appeared.
I'm only performer here.
Contempt case.
Nothing to do.
Contempt, Mr. Ratan was appearing.
Let us see what is the contempt. Still there is a contempt.
Yes, my lord. Because this honorable court has stayed holding of the interview. And despite of that, they hold the interview for a particular post and appointed a person.
Where is the Ratan? Where is the violation? And writ petition is still pending.
Yes, my lord.
What is to be determined in the writ petition?
Here, they have filed a affidavit, my lord.
Shall we do it in the month of August?
Yes, my lord.
Huh?
Pardon, my lord.
Shall we do it in the month of August?
Yes, it can be done in August, my lord.
Heard Mr. D. Laji, Islamic Council for the petitioner. And Mr. T. Tagun.
For respondent number.
You are in contempt case, no?
Well, I'm not in.
Okay.
Main case.
You pass in the contempt case. Non-appeals for the respondent. In view of the. You state after 3 weeks, we'll say, 3 weeks. And in writ petition, had Mr. D. Laji, counsel for the petitioner, and Mr. T. Tagu. You are extending counsel health department.
Yes, health department. for-
You can respondent number
Two.
two. Okay. None has appeared for the respondent except Mr. Tagu, and extending counsel health department, you can respond to. In view of the, you state again after 3 weeks.
Most of them.
Yeah. Twenty. Four.
Yes.
Where is? Matter survives or what?
Lordship, Lordship, see the page 10 of my affidavit. It's a, no, it's a photograph. Lordship. Lordship will find here, Lordship, the retaining wall has been constructed up to the Lordship. Page 10 annexed to the-
Yes.
Retaining wall has been constructed, Lordship, up to the point where there's a dispute, Lordship. So far road is concerned, it has been already constructed, Lordship. Only this portion, if this retaining wall is continued, the lane of the petitioner, it will be protected, Lordship. Now, our contention is that, Lordship, this area of 2 meters is comes under the Lordship, the lane of the earlier lane, Lordship, the road, Lordship.
Road,
Lordship. The existing law has been already widened, Lordship.
non-appeals for the petitioner. Had Mr. S. Tapi, senior government advocate. And Mr. J. Kamla, standing counsel for the department for the respondent. In view of the list today, after 4 weeks.
May I please? My lord, in this case, petitioner is aggrieved by letter dated, my lord, 15th of February 2023, issued by the respondent number 3 to the respondent number, my lord, 5, seeking my lord, Department of Police personnel for carry out the eviction order which was passed on, my lord, 21st November 2021, my lord.
Page number?
My lord, the first order is, my lord, page 26. My lord, before that, my lord, if my lord recalls the last order, my lord, my lord, they have taken time to seek instruction from the respondent authority, my lord, whether my lord cause of action is still survives or not. My lord, and one thing more, my lord. In my lord, similarly situated case, my lord, wherein this interim order has been also challenged. My lord, this honorable court is closed the writ petition, my lord, on the consideration that, my lord, since eviction has been already done in that stretch of road, my lord, therefore further eviction will not be necessary. My lord.
Yes, Mr. Rira.
Lordship, in this, the one we have so, but no instruction is there, but in a similarly situated case in Massam legal, Lordship, we got the instruction that since road has been already constructed, so eviction would be no longer
Necessary.
in it. So the petition was disposed.
So paragraph 2, man, page 2. Paragraph 2.
You have to bring instruction. Matam Lingi cannot be, Matam Lingi and Kagaopi are different persons.
Lordship, different
Location is different, person is different.
location,
Location
location in
is
the same line.
So what is your submission, Mr. Iram? If you say close it, we will close it. But we will not close it on the basis of this order. Matam Lingi is Lingi, OP is OP. Huh? Close it.
After
No further widening is necessary.
in there, Lordship, we have specifically that the was also discussed, but I will take further instruction. Lordship.
You remember what was the last order?
Lordship,
Onus is on you now. You had taken the responsibility of taking, receiving instruction and then informing this court. But from the submissions which you are making, it appears that you have forgotten the last order.
no, Lordship, we have sought instruction in this regard, but they have
Okay.
not given here.
What is to be done?
Well, even some time, my lord.
After I will, Lordship.
Hmm?
We will again
Next week, my lord.
next week.
You will be able to bring instruction.
Lordship.
How you will receive the instruction? You have to able to get the instruction, is not it?
Lordship. No, we saw the same instruction there and here also in the same manner, but there we got, here we have not been provided. That's all, Lordship, the difference.
Here it was, there it was not you who got the instruction.
No, it was.
It was Miss K. Wangmo who got the instruction.
Instruction was, Lordship, sought by me.
Not by you. So then why you have not been able to receive it here? If you can, we'll post it next week. Otherwise, we are against listing of this case, listing of any case in such a short interval. If you are confident, we'll post it next week.
No, Lordship,
Huh?
next week.
Sure.
Lordship.
On the prayer of Mr. Rira, I Rira, additional senior government advocate. On the submission made by the Mr. I Rira, additional senior government advocate, that he will be able to receive instruction from the respondent authorities by next week, as directed by this court, by the order dated 24/5/2023. Let this liquidation be listed after a week. All right.
Yeah, Lordship. Lordship, on behalf of Mr. Pada, Lordship, we may allow some more time to file affidavit in reply in respect of respondent number 3 and 4.
What is the matter about?
This matter is regarding Lordship, election of panchayat, Gram Panchayat member pertaining to setting aside a quashing of order passed by the Deputy Commissioner Rowing. Election, this is election matter, Lordship.
Election matter,
Election matter of Gram Panchayat member.
Gram Panchayat member. You are challenging the election of a Gram Panchayat member.
We are challenging the orders passed by the Deputy Commissioner.
Your Lordship, they are challenging the disqualification.
Yes.
Okay.
Disqualification order issued by the Deputy Commissioner, Your Lordship, from being a member of Gram Panchayat members.
In file affidavit.
Lordship, I'm representing respondent number 1, that is State Election Commission. We are not filing affidavit.
Okay. Deputy Commissioner has filed affidavit.
Yes, Your Lordship, we have filed our counter affidavit.
So you want an adjournment?
Right, Lordship. For some time, we will file our reply.
Reply.
Your Lordship.
You have taken 3 times.
Right, Lordship.
To file. No, not only 2 times, 5 times. To file reply. On the prayer of Mr.
May I, Your Lordship? Your Lordship may give direction to the registry GA to be reflected in the cost list, Your Lordship.
Okay. On the prayer of Mr.
J. Saro.
J. Saro, counsel for the petitioner listed after 4 weeks to file a reply to the counter affidavit filed by the respondent number 3.
May, Lordship. As well, Lordship, we have to take fresh step against respondent number 5.
I will been served.
But Lordship, it's not yet received by
Service will notice.
or fresh steps.
Back to this. Like, yeah. Six weeks. List it after 6 weeks, example, by spring and
May, Lordship, there was an interim order, so we continue.
what kind of interim order? Yes, interim order.
Lordship, interim. Yes, Your Lordship, interim was granted on 18/11/2021.
18/11.
2021. Order dated 18/11/2020.
Okay,
The order of the DC was stayed.
all right. 6 weeks.
Obliged.
Much obliged.
By spelling the name of GA in the court list. In the remote part, let's continue to the next date on this.
May I please, my lord? My lord, this contempt petition can be closed today as the respondent authorities
Have
with
complied
their
with,
additional, they've acknowledged my entitlement for compensation.
okay,
So it can be closed.
they have complied with the other parts in the writ petition.
Yes, they have acknowledged that I'm entitled for compensation. And their additional affidavit, Annexure 7.
Mr. S.K. Jamal, counsel for the petition and Mr. Tapian, you are agreeing for respondent.
Close.
Counsel for the respondent. Mr. Jamal, counsel for the petition and submit the other parts in the writ petition has been complied with by the respondent authority, by the respondent. How many respondent?
There are 3 respondents, my.
Okay, by the respondents. For which he pressed for closure of the contempt petition.
My lord, there is the averment can be whether it can be reflected on the order. That their decision white interment for the compensation as per the verification dated 18/4/2020.
No, just a moment. Where is the order passed in the writ petition?
Order first.
Page 13.
Yes, where? Which one you want to be reflected?
My lord, in the additional affidavit, my lord,
Additional.
filed by the respondent number 1, DC Anjao.
Yes.
Para 2. Paragraph 2. 2. Yes. Paragraph 2 there in the middle of the paragraph, there's accordingly, white order dated 24/20/22. It has been decided that the petitioner would be entitled for the compensation as per the verification dated 18/4/2022. However, since the compensation and connected issue for the entire stretch area need to be collectively disposed of, therefore the compensation shall be released along with others after all necessary formalities, including the government approval, has been taken.
Okay, had Mr. Petitioner, Mr. Jamal, additional, the counsel for the petitioner. This contempt petition may be closed. In, just a moment, yes. This contempt petition has been filed alleging violation of order with 3/6/2021, passed in WBC 161/2021. Mr. Jamal, counsel for the petitioner, submits that this contempt petition may be closed in view of the statement made by the Deputy Commissioner, who is respondent?
Respondent number 1, DC Anjao.
Respondent number 1. In paragraph 2 of the additional affidavit filed by him. Where is accepted. And accepted. Contempt petition stands closed. In view of that, this amendment made by the respondent number 1 in paragraph 2 of the additional affidavit filed by
Highly.
May I submit?
Yeah.
In item number 28, my lord, I require to file affidavit in reply, my lord. I am paying sir that is to affidavit opposition filed by state respondent, my lord. I beg some additional time, my lord, to file the reply, my lord. In item number 28.
In 28, you want to file reply.
My lord.
Any objection?
No, your lordship.
Okay, then what is 29?
29 contempt, my lord.
Oh, contempt. Oh.
Contempt.
What is to be done to the contempt?
Contempt, my lord, I have placed on record, my lord, to the service of notice, my lord. So of the dusty, my lord, so affidavit, my lord.
In read petition, who appears for whom?
I'm appearing for representing respondent number 6, my lord.
Okay, and Ragum for 6, huh? Okay. For 7, and you have
I am for respondent number 2 and 5.
2 and 5. Who else? Pangu?
Yes, I'm for respondent number 1, 3, 4, 5, and 6.
Okay.
6. I'm appearing for 6.
Okay.
Highway, then executive engineer highway.
1, 3, 4, and 5, your lordship.
1, 3, 4, and 5. On the prayer of Mr. L. Cornet, the only counsel for the petitioner. How much time?
3 weeks.
3 weeks time is granted for filing of the rejoinder to the counter affidavit filed by
2 to 5, my lord.
respondents 2 to 5.
2, 3, 4. They have filed 2 affidavit, my lord.
I am not filed.
Huh?
I am not filed. Respondent number
We have filed, my lord. Respondent number 6.
2, oh, sorry, my 3, 4, and 5, my lord. 3, 4,
Okay,
and 5.
3, 4, and 5.
6 also have filed, my lord. I also beg to file affidavit to that also, my lord. 6, my lord.
As well as by respondent number 6. Okay. List it after 3 weeks.
3, my lord.
3 weeks. Yes, what about contempt?
Contempt, my lord, is this may be listed along with this also, this, my lord. I have placed on record, my lord. I have service of notice, my lord, to all the
Which order
respondent.
has been violated by whom?
Order, my lord, was passed in same WPC, my lord, the order at 31/10/2022, my lord.
Huh?
31/10/2022, my lord. Order
Yeah.
was passed, my lord.
By whom? The officer in charge?
Yes, all, my lord, all the respondent, my lord. Not only, my lord, officer, my lord, OC, my lord, was directed to register the case, my lord. I am informed, my lord, he is yet to register the case, my lord. And thereafter also, my lord, execution of the work, my lord, was continued, my lord.
Okay. So it can't be closed.
It's normal. It need to be.
Who appears for whom? Yeah.
My lord, we have no instruction regarding the contempt.
Contempt.
No instruction.
Notice has been served.
Yes, my lord, I have placed on record also, my lord, by my affidavit, my lord. I have filed, my lord. Dusty
So,
circular.
all right, well, then list it along with mobile. List it along with.
Always be.
My lord, on my prayer, this honorable court has passed an order
for causing service to the respondent by substitute service by publishing in a newspaper. But my lord, after obtaining the order of the dishonorable court, I have applied for permission to the registry, and the registry has granted permission, but to publish in Arunachal Times. But the respondent number 5 is residing at Tinsukia. Tinsukia. Kendra Vidyalaya Sangathan. And common order has been passed for causing service of notice to the respondent number 5.
What is that order?
You know, it is in IA. Order dated 9 June 2023.
9/6. No, there is no mention of Arunachal Times. Newspaper it says.
No, I have obtained permission from the registry. There is another notice, my lord.
Where?
It is page number next to order, my lord.
Okay. So, respondent number 5 is Kendra Vidyalaya.
Kendra Vidyalaya Sangathan.
In all the writ petition.
No, respondent number 5 is different in different writ petition. So common order has been passed. So there is some defect, my lord.
Defect.
In Narang Kancha's case, respondent number 5 is Bolo Babu. And herein, respondent number 5 is Kendra Vidyalaya Sangathan.
How many writ petitions?
3 writ petitions are there. And 1 contempt petition is also there.
So this writ petition 2 of 23.
Yes, ma'am.
57 of 20.
No. The present case is writ petition 270.
270. So this order has been passed in all this writ petition.
Yes, common order.
223, 57,
57, 02.
Now,
the persons are different in different.
In 270, respondent 5 is the Kendra
Vidyalaya Sangathan.
Then in 57?
In 57, Bula Babu.
57, Bula Babu. He is also to be. No, 57. Okay, just. Ah, 57, it is Blue Babu. Then in 2,
Kendra Vidyalaya.
Whom you have to serve notice?
In different writ petition, I have to serve notice to different respondent, my lord. In the present case, in item number 36, in writ petition number 270. 270.
Whom do you want to serve notice? Bulo Babu or the Kendra Vidyalaya?
No, here Kendra Vidyalaya. Here Kendra Vidyalaya.
Okay, to Bulo Babu also you have to.
Yes, in another writ petition.
Under writ petition. Bulo Babu is in 57, I think.
57.
57 is Bulo Babu. And writ petition 2 of 23 and 270 There it is Kendra Vidal.
Kendra Vidyalaya.
Okay. You want to serve both this?
My lord, I want to add some more respondent to serve notice. In the present case, PWD also,
See, this application is for what?
for modification of the order dated 9 June 2023.
Ah. So, to that extent only,
Yes, madam.
so we'll modify it.
Yes, madam. Separate order may be passed in different cases, madam.
Okay. This IA is in which case?
This is in
This
writ petition
IA means what?
270,
Just a moment. What is the number?
270, madam.
No, IA number?
I number 123,
123. It is in 270.
270.
Okay. 270. The 270 means Kendra Vidyalaya.
Yes, Kendra Vidyalaya also, but executive engineer, respondent number 5. I want to serve both of the respondent. Executive engineer, PW0 and the Kendra Vidyalaya.
No, executive, they will appear.
They are not appearing, madam.
Why?
It is already. Of course, will appear lots.
We have taken step, madam.
What?
We have taken step, but they are not appearing.
Executive engineer, which department?
PWD.
So why the government advocate shall not appear?
What's it? We never say so. We have already filed our affidavit.
In
It
respect
is
of
already.
in respect of respondent number 5, deputy commissioner, they have filed
Deputy Commissioner 0.
0.
No, but she is also representing
PWD.
executive engineer.
Is it? No, if it is there, then only one. Only one.
Only one.
Yes, madam.
Lordship, let me check out if we met the executive PWD 0. What's it?
4 and 5.
Lordship will represent Lordship. From
Yes.
our side. Lordship, otherwise, the pleadings are almost complete. This KB, I doubt they will come because they are the institution which the government has, Lordship, invited them to establish, Lordship.
No, but then since they are party, whether
Lordship.
they come or not, that is up to them. But notice will have to be served.
Yes, Lordship.
So you want to publish in which newspaper?
My lord, the newspaper which is circulated in Tinsukia, I'll publish in that paper.
Which newspaper?
My lord, I will inform the registry
No,
at the
no.
time of taking
It can't
permission.
be on registry. We have to mention here.
Immediately, I cannot say, my lord.
There is no mention of any newspaper.
Immediately, I cannot say.
Assam Tribune.
Assam Tribune, that will do.
I think it is widely circulated.
It is widely circulated. Assam Tribune.
This is an application. Filed by the applicant seeking modification of order dated 9/6/2023. Which is a common order passed in WPC 2/23, 57/20, and 270/2022. Whereby prayer made by the Islamic Council for the petitioner for causing service of notice upon the respondent number 5 by newspaper publication was allowed. Full stop. The modification of the opposite order is sought on the ground that no no particulars of the papers. No particulars of the newspaper was no particular of the newspaper on which the notice is required to be published was indicated, and more so the respondent number 5 in WPC 223 and 270 of 2022 then is a resident of a place is 223 and 270 22 is a resident of Tinsukia, Assam, whereas the respondent number 5 in WPC 57/20 is a resident of 0. So accordingly, the applicant contends that publication of the newspaper notice in the newspaper will have to be in the different newspapers for the respondent number 5 in WPC 223 and 227/2022. Then in the case of respondent number 5 in WPC 57/20. Full stop. In instant application, respondent number, the applicant has also sought for causing service of notice upon respondent number 4 by substituted mode. Full stop. However, on perusal of the respondent, respondent number 4 is found to be an executive engineer, PWD Division 0, Government of Arunachal Pradesh. And in that view of the matter, the respondent number 4 is duly represented by Ms. G. Ate, an additional senior government advocate. Thus, no notice is required to be, no formal notice is required to be sent to the respondent number 4. Having regard to the having regard to the prayer made by the applicant for modification of the order dated 9/6/2023 for causing for causing service upon respondent number 5 by substituted mode. This application is allowed by providing that the petitioner shall take steps to cause publication of the notice upon respondent number 5 in the newspaper in the Assam Tribune newspaper within a period of 3 weeks.
Yes, madam.
3 weeks from today by showing the next date of appearance on
Well, next date may be given 11 September. 11 September.
18 September.
18th order, no.
18 September. Full stop. After the apposite notice is published in the newspaper indicated above, the applicant shall file an affidavit enclosing copy of the newspaper where such notice had been published. Now, yes, whether the other IA?
The next is contempt case.
No. How many IA you have filed?
4 sets of IA.
Whether those IA?
Yes, madam.
This is in IA 123. Now, which is the IA in 223?
That is in IA 126.
126 is
Here, my lord, alleged contender is former deputy commissioner. Now she has been posted to Goa.
just a moment. IA 26 is it is in contempt case.
Yes, contempt case. Here also, I want to call the service of notice.
One by one, Mr. Let you see,
No,
you are making a mess of this
no,
case.
my lord, as per cause list. As per cause list.
You take the IA file in WPC 2 of 23. And this situation would not have arisen had you organized yourself and place the matter before the court appropriately. Which is the IA file in 2?
IA file in petition 2. It is 124, madam. 124. 124.
Where is 124? Yes. So in 124 also some order has to be passed or not?
Common order was passed earlier. That has to be modified now, madam.
No, 124 is Mr. 57. Your IA filed in WPC 2 of 23, Mr. Where it is again the Kendriya Vidyalaya.
No.
57 is Bulo Babu.
57 is below Babu.
So we have to pass the same order. See, in the Assam Tribune, Bulo Babu's notice cannot be published in Assam Tribune.
Yes, madam.
So which is the IA which we have filed in WPC 2 of 2023?
124, madam.
124.
IA 124.
It just.
It should be 125.
It should be 125.
You
don't know anything about your case.
123 is also there.
I expect.
123. Earlier, this is 124.
My lord, I am
Narang Chatung is 124.
125.
उसको दिखाओ ना 124.
125, 125.
You have said 124.
Sorry, my lord, 125, 125. 125.
125.
Madang. Right. Okay.
You may be in a hurry. We can't be in a hurry.
Sorry, my lord.
We have to pass a correct order. Same order.
Same order.
This is 125. IA 125. Now come to WPC, your IA file in 57. 57.
157.
That is not 157, WPC 57. That is 124.
Just a second.
Yes, Lord. 120.
120.
Earlier one was 123, huh? 123.
In Tagaritai's case, it is 100.
It all is, see, as because of the last order,
Yes.
unnecessarily wasting our half an hour time. Then this gives right, rest will remain same. On the part where it is modified part. By providing that the the applicant shall take steps for publication of notice upon respondent number 5 in the Arunachal Times. Within,
My lord,
period of-
four also. Four also.
Who is for Mr. Koyang?
Okay, PW again, PW. All right. All right.
Within a period of 3 weeks from today. By saying the next date of appearance, except the same, huh? 18, right? Affidavit also. Yes.
My lord, I'm very sorry, Lordship. In fact, in the last item, supplementary hearing, Lordship, all of us are the party, Lordship. It
No,
is
that is-
unlikely that it will be.
No, he has another IA.
All
In the
those-
contempt case.
Contempt case.
Yes.
My lord, here, respondent number. Yes. Respondent number 3. The deputy commissioner, earlier former deputy commissioner. She has been transferred to Goa. Now she is posted as director industry at Goa. So I have to publish paper in the national newspaper, the Times of India. And the Secretary Land Management, he has also been transferred from Arunachal to Delhi. Now she is special secretary to Governor Delhi.
Lordship, this is a contempt matter, personal matter. I shouldn't be submitting here. But then Lordship, if Lordship,
In this-
members, Lordship, this contempt has been filed when there was the status quo order. that was not there anymore, Lord. They didn't continue the interim order.
Which
At
is
that time,
Which is the order?
this
you are
order was
Alleging violation?
contempt was filed.
Contempt case?
So
My
unnecessary.
lord, no, this is not unnecessary, my lord. During the pendency of the matter, when this court has passed an order for maintaining status quo, then a building has been constructed, my lord, in violation of the order of this court.
Which is the order?
Order is in page number 30, my lord, and the operating part is page number 43. When this order was enforced, the respondents have constructed a building in the disputed land, my lord, in violation of this order. Therefore, this contempt petition has been filed against them.
What happened to this IA 63?
IA 63
of 2020?
Well, the IA 63, the IA filed for restoration of the status quo that has been granted, my lord.
No. What happened to that IA? It is pending or disposed of?
For extension of the status quo that has been disposed of.
Page 43 is the order violation of which you are alleging to the respondents. Is not it?
Yes, madam.
That order was passed in IA 63.
IA 63,
What
yes.
happened to that IA? What happened to that case?
Now, that has been disposed of.
Disposed of. Okay. Then. Yes, where is the?
Then another IO was filed, my lord.
No. Then where is the evidence made in the contempt petition that
Regarding
Yes.
violation, my lord.
order dated 25?
Yes, my lord, para 7. Very long one. 7 and 8, my lord.
Okay. Yes.
My lord, here, none of the respondent appear in this court. So I'd like to pray before your lordship to allow me to cause service of notice by publication in the newspaper.
Newspaper.
Yes, my lord.
In respect of whom?
In respect of respondent number 2, 3, 4, and 5.
Two, three, 4, and 5.
4 and 5.
Who is 2?
2 is Secretary Land Management. Sonwal Swarab by name.
And who is 3?
3 is Srimati Sotika Sachin, former Deputy Commissioner.
And who else?
4, Sonal Swarab, he is posted at Delhi.
No. Who else you want to serve notice?
Secretary Land Management, former Secretary Land Management.
No, that you have said. And the Deputy Commissioner.
Yes, madam.
Sonal Swarab and Swatika Sachin you have said. And who else?
And the next, Hage Moving Executive Engineer, respondent number 4. And 5-1 Sri Bulo Babu.
Have you checked out the record?
Case record.
Yes.
Relating to my lord.
Relating to what is relevant for you to know.
Yes, my lord.
Whether notice to take the name to the respondent 2 and 3 have been served or not?
Yes, I have served, madam.
You have served?
Yes, madam.
Then why you want to again serve?
No, notice means before filing contempt petition, I have served notice, contempt notice. And regarding.
I am hearing it for the first time. That before filing a contempt petition,
Contempt notice I have served, my lord. And after filing this contempt petition, I have taken a step, my lord, through post office.
After hearing the learned counsel, Mr. S. Goyan, for the applicant in IA 126 AP of 2023. I find I find that the contention raised in the interlocutory application file and the prayer made is not in. So there is a variance in the contention raised in the interlocutory application file and the office notes recorded in the contempt case. In view of the above, in order to enable the learned counsel for the applicant, Mr. S. Goyan, to verify as to whether the contention raised by the applicant in the interlocutory application file is in variance with the office note, with the various office notes recorded in the contempt case number 16 of April 2023. This matter after 4 weeks. You, next time you go and be careful. You have wasted our 45 minutes. Respondent 2 and 3 have already been served notice. And respondent 2 has had some sent communication also, which is placed on record. You again want to serve notice.
Sorry, my lord, I have not gone through the contents of the documents.
And right from the beginning. This is not the, in this sets of writ petition. This is not the, in earlier occasion also, we have wasted so much of time because of the mistakes committed by you. You remember?
I don't remember.
You don't remember.
Only I know that they are not appearing. So I am trying to take a step against them by substitute service. I think I should go through the contents of the file.
6 weeks, 6 weeks. Yes.
I am sorry, my lord, whether it is appropriate to mention this matter, Lordship. Here in this matter.
No,
item
let
number 42,
let the item be called.
Lordship.
My lord, I have received the copy of the IA this morning. IA, they have filed for vacation of the interim order.
Yes.
I may be given at least 1 week's time to file application. In the meantime, Judge, I will also file all the other necessary applications and pleadings. I'll make an effort to complete the pleadings on my part.
I is filed by whom?
Filed by.
Filed by the respondent 10 and 11. Because they were not implemented earlier occasion, they were not implemented as party, and the Honorable High Court has allowed them as to implement as a party. So they are actually affected person. Hence filed this IA for the vacation of the.
You want to file a reply?
Yes.
My lord,
Petition
here.
is filed by whom? You?
Yes.
What is the matter about?
Writ petition, my lord, a NIT was floated by PWD department for extension of road for an amount of 98 lakhs. On the last date of submission, on the last date for submission of tender documents, my lord, I was prevented by some persons from submitting the document. That is how I approached before, my lord. Initially, the respondent numbers 10 and 11 were not implemented. They filed an application for implement, and my lord allowed the implement application. That is how they were met parties, were met as respondent numbers 10 and 11. They have filed the present IA for vacation of the interim order dated 28/4/2023.
In the writ petition, government has filed affidavit.
Yes.
Okay. Then we take on the writ petition itself or?
Yes, my lord, that is far better. Because even the government has already filed their affidavit by the respondent number 1, 2, and 3.
Have you filed affidavit? No, you are the petitioner.
Yes. The petitioner.
Have you filed affidavit?
No, it's not that.
I have not filed affidavit, and I have recently been implemented, and I have filed this IA for the vacation of the interim order.
Would you like to file affidavit? Counter affidavit?
Yes, my lord, as per procedure, I should file affidavit. But by this petition also, by the complying with the respondent number 2123 also can be disposed the instant writ petition.
No, it is up to you. You are, if you are ready for disposal of the case without your affidavit, we'll go ahead.
Yes, my lord.
Okay. You are representing whom?
I am representing respondent number 10 and 11.
10 and
11.
11.
Yes, my lord.
Who are these 7, 8, and 9? Who is representing? No.
But-
5, 6, 7, 8, and 9.
Malad, on the last
5,
occasion-
6, 7, 8, and 9 are not represented by anybody.
Malad, on the last occasion, I had prayed for allowing me to take steps to justice service. Malad. This morning, my lord, I have submitted the required documents in the registry. Malad. In a day or two, registry will give me the notices. My lord. I will accordingly take steps. My lord.
You are permitted on 10, okay, 10 July, 10
10.
July.
Before that, my lord, I had taken steps, but then the notices
All
returned with
all right.
endorsement that addresses were not found.
My lord, that will be better if the matter is fixed for final disposal after, as per by contention made by the.
Let notice be served.
So.
See, it is very confusing. You are petitioner here. You stand here.
No, my lord, I'm the respondent in his IM.
Nevertheless, you are the petitioner here. You come this side.
Okay, my lord.
It's very confusing.
Yes, for this, only for this IA. I'm the petitioner.
IA 128.
128.
Hey, what is this IA 99?
My lord,
98?
this.
What is
My lord, this IA is filed by the respondent number 10 and 11 for the petition of the interim order.
IA 99 has been disposed of.
IA 99 is already being disposed of, my lord.
98 is also disposed of.
99 is disposed of as it was for the implementing as a party. So he was accordingly, they were implemented as the respondent 10 and 11. So it's disposed of.
Then. Mr. M. Nemo, London Council for the applicant. So respondent number 10 and 11. 10 and 11. 10 and 11 in the writ petition. And Mr. R.L. Tungam, London Council for the opposite party, the writ petitioner. This is an application seeking modification, alteration, and vacation of the order dated 10/7/2023. No.
28/4.
Page number.
$37 million.
Okay. Order dated 28/4.
2023.
Passed in WPC 202 of 2023. On perusal of the case record of WPC 202 AP of 2023, it is noticed that the counter affidavit by the estate had been filed. However, the applicant stock respondent number 10 and 11 have not filed counter affidavit, nor respondents 5 to 9 have been served notice by the petitioner as directed by the order dated 10/7/2023. Mr. R. Tumman and counsel for the writ petition has submitted that the process to serve notice upon the respondents 5 to 9, no?
5 to 9.
5 to 9 in terms of the order dated 10/7/2023 is under process. Also, in view of the above, let this interlocutory application as well as the writ petition be listed
After a week.
3 weeks.
No, after a week.
Huh?
After a week.
After
As
2
prayed by, as
just after 2 weeks. In the meanwhile, notice upon respondent number 5 to 9 shall be served by the petitioner, by the writ petitioner in terms of the order dated 10/7/2023
and
23. Also, the respondent number 9 and 10.
and 10 and 11.
You are 10 and 11. Oh, sorry, 10 and 11. Who are the applicants, huh?
Yes, madam.
Applicants in this interlocutory application. May file counter affidavit if so advised. Okay, listed after 2 weeks.
Now, in the main writ petition, interim order may be continued.
Interim order passed in WPC earlier, writ petition earlier, shall continue till the next letter list.
Oh, let's-
Yeah, please, madam.
Yes.
Madam, by last order, the respondents was given last chance either to file affidavit in opposition or to sort it or to take a instruction.
Who is the respondent?
Respondent, Central Malal, M. Katoman,
Union of India.
Union of India.
He himself is not there. Today, I think he is not there.
Yes. Not there, madam.
What is the matter about?
Matter is, madam, dismissal survive, dismissal is no more survive now. Because I was initiated a criminal proceedings. In criminal proceedings, I was convicted till rising of the courts. And in view of that, my service was dismissed. And accordingly, I challenged the dismissal order as well as this conviction order. Then this honorable court was both the dismissal as well as conviction order. And liberty was given to the respondent authority to reconsider a press available evidence available in the records. Then accordingly, respondent authority convicted me. But that dismissal order, which has been quashed, is no more survive now. And they have not passed any consequential order after that.
Okay.
So in my writ petition, I'm sought for the service benefits, and my service, since my dismissal order has been set aside, and my lord might take consideration that to be deemed served in the service, my lord. I was initiated for criminal proceedings for overstay of 83 days.
Neither instruction.
Yes.
Nor
affidavit. Yes. Been pending since 2018.
What to do? Let us pass order in his presence. Then you list it next week.
No problem, my lord. Then may I pay for the fixed date
When?
on 27th?
27.
And my lord, last order may be reflected again, my lord. Last order, last chance and.
Okay. How does the secretary? Not abuse for the respondent. We have never when as paper when Mr. Tari and control petitioner. Let's sit on 28th.
Last order, last chance.
I will take a note of that.
Okay. Okay.
But your contention is tenable. What you contend is tenable.
Yes.
Okay.
My lord, since there is no time, Lordship, we would like to get the matter listed on 18th of August. This case has been pending since last 2018. And there is in fact urgency in disposing.
What is the matter about?
This is regarding non-selection of the petitioner as a LDC.
Okay.
For the interview which was conducted in the district level at Teju.
18th of August.
No, 18th of August.
Okay. And well, you are for the petitioner.
Yes, Lordship. Lordship, may kindly this matter may be fixed in the top of the supplementary hearing list, Lordship.
It should come on the top of your list because it is 28 meter, so 18 meter.
Lordship.
It will come. On the prayer of Mr. D. Gamble, the petitioner, GH, another associate as well as Mr. Cohen, as for. Which respondent for the private respondent listed on 18th of August for hearing.
Much obliged.
All right.